Hello, all the CA Inter students. This is your CA Koushik Mukhesh, and we are now going to start with a super quick revision of expected questions marathon from the question bank directly. Rather than reading the concept and wasting our time, directly we will go on the point as per the expectations of ICA. Target is very simple, 60 plus in law paper. That will be possible only when we understand the concepts in all the chapters relating to the law paper in detail for the coming examinations. And we are going to start first with preliminaries, and I'm going to have the discussion in the order of the chapters. Means preliminaries, incorporation, prospectus, share capital, deposits, registration of charges, administration, management and administration, properly called as the general meetings, dividends, accounts, audit, foreign company. Like that, in this sequence only we are going to have our discussion. And expected questions marathon, only what are expected for this examination, on that areas we are going to put our analysis and complete. Wherever required, we will also see the charts and we will try to make some analysis. So main focus exam, on point for the exam we are going to do the discussion. And listen to this, you will definitely get 60 plus in the coming examination if you listen to this lecture completely, because you are going to revise along with me as per the ICA question paper. Okay, let's begin. Question number 1. Expected questions in this chapter, body corporate is one expectation. See here, in body corporate, what they will ask, they may not ask you define a body corporate, but they will ask a question on body corporate. How they will ask? Whether this is a body corporate or not, like that a question can come. First, remember one thing, body corporate definition is wider than company. Company means what? Only companies incorporated under Companies Act, companies. But body corporate includes a company. Means what? Body corporate is not a company. Company is also a body corporate. Means in body corporate, company is one of the entry. Okay, what do you mean by company? Indian company is called as a company because company incorporated under Companies Act in India. So body corporate includes company incorporated outside India. What does the lawmaker wanted to tell? Body corporate la not only Indian companies, foreign la incorporated companies are also body corporates. Okay, but does not include two things: cooperative society and body corporate notified by central government. Like that you have to remember. So definition completed. And what is a body corporate? Body corporate and body corporate includes a company incorporated outside India. Means it already included company incorporated in India, LLP incorporated in India. Everything is already included in that. Okay, Indian company, body corporate. Indian company, body corporate. Indian LLP, body corporate. Foreign company also is a body corporate. But body corporate definition, cooperative societies and notified body corporates are not included. Over. Next, very important definition, private company. What definition? Yeah, private company. I will first explain you. Private company, how they will ask a question, I will tell you. First, let us read what is a private company. Private company is a company. Okay, very good. Having minimum paid up share capital. Articles of association of a private company will do three things: restrict transfer of shares. Okay. Next, restrict transfer of shares, limit number of members to 200, prohibit public subscription of securities. Three things. Private company means a company which is private company means a company which is having minimum capital. Without capital, you cannot incorporate a private company. In the articles of that private company, three things will be included. Number 1, restriction on transfer of shares. Number 2, limitation on number of members to 200. Number 3, prohibition on public subscription of securities. Answer over. However, we are going to discuss on limiting the total number of members to 200. In this 200, some are not included. Who are that some that are not included into this 200? They say two things. Number 1, okay, employees. Number 2, joint holders. Joint holders will be treated as a single member. For example, husband and wife held shares. How many members? One member we will count. HUF, 30 members are there in HUF. Karta purchased the share. Who is the member? One member, a member. Okay, all 30 members, 30 number ki we will not count. Group will be counted as one because it's a joint holding. Next, employees are two types. Number 1, present employee. Number 2, past employee. One is present, another one is past. Present employees are excluded from 200. Are excluded from 200. Okay. Past employees are of again two types. Okay. When you became a member, I became a member during employment. I became a member before or after employment. Two situations. When you became a member, I became a member while I am in employment. Second, I became a member not during employment, either before employment or after employment I became a member. You will be counted into 200. This will not be counted as a member. And what does it mean? In exam, they will ask a question like this. See how they will ask. There is a private company. In that private company, there are 10 employees. How many? 10 employees. On 1st April. On 1st April. These people, okay, continued in the company. Employees, I said. These people continued till 1st June. Which June? 1st June. 1st June, they were given with 100 shares each. 100 shares. Shares, not shareholders. There are 10 employees. Every employee was given with 100 shares. And how many shareholders are added? 10 shareholders are added. But this will not be counted in the total number of members because they became members while they were in employment. Present employee category. Okay, done. Now what happened after some number of days? Let us say on 1st September, these employees resigned. These employees what? Resigned. They resigned and they went off. Okay. Employment, they resigned. Shares are still there. Even now, they are not counted because they are past employees now. So, because they are past employees and they were allotted with the shares while they were in employment. So, even now, even though you resign, you are a past employee who got the shares while you are in employment or not. Again, I will not consider you into the 200 number. And into the 200, these 10 are not included. Okay, very good. Now what happened is a story. See what they have done. These people sold the shares. These people what? Sold the shares. Sold the shares on 1st October. Sold. Now they are no more members. Now they are no more members of the company. They are not members. And now they are not employee. Now they are not even members. Over. Their link with the company is completely lost. After that, on 1st November, they purchased shares again of that company. On 1st December, they again became employees. Now, you are employee, you have the shares. So you will not be counted. Like this, you should not think because they were not allotted with the shares while they were in employment. They were allotted with the shares while they went out and they were not even past employees who allotted with the share. Those shares already they sold. I think you understood this example. In this, like this, they can ask a question in exam. For that only Koushik Mukhesh is now taking an effort for you to make you understand how they can ask. I am going very fast, so you should listen to the first go. Whoever did not understand this, pause, go back, listen again. I can't repeat one more time. Okay. Next, other private company definition. So, provided that where 2 or more persons are holding 1 or more shares in a company will be treated as a single member. Next, provided that persons who are in employment, present employees, who having been formerly in the employment, past employees, were members while in employment and continue to be the members after employment is ceased. But you did not continue, you sold the shares. Again, you became a member. Now this condition is lost. Therefore, you will be included. If you satisfy this, shall not be included into total number of members. Done. Next one. Holding subsidiary and associate. One stretch we will cover. Okay. For that, I will directly discuss here. See, there are 3 types of companies on the basis of control: holding company, subsidiary company, associate company. Exam if a question comes, section number mandatory. Section 2 class 46, section 2 class 85, section 2 class 87, section 2 class 6. Write down the section numbers properly. That's why clearly in my material also I gave 2 class 46, 2 class 87, 2 class 6. Okay, first section numbers. Holding company means what? Holding company in relation to, subsidiary company in relation to, associate company in relation to. This is first expectation of institute. You should write these 3 words whenever a question comes. See here. Holding company in relation to, subsidiary company in relation to, associate company in relation to. This is a relationship only. This company, no one incorporate holding company. After getting incorporated, it's a relationship. These 3 sections are telling about relationship. Okay, relationship of one company with another, parent relation or associate relationship we are going to discuss here. So clarity in mind. So holding company means what? Holding company in relation to one holding company. Holding company is a parent. Parent can have multiple subsidiaries. That's why language is very clear. One or more other companies. Okay. Subsidiary company means children. Child can have only one parent relation. So subsidiary company means subsidiary company in relation to any other company, that is to say a holding company. Like this you need to write in exam. See, that's why holding company in relation to one or more other companies. Holding company can have subsidiaries. Okay, subsidiary company cannot have holding companies. It can have only one holding company. So subsidiary company in relation to any other company, that is to say a holding company. Then they will tell means a company, means a company. Comparison we are reading. So holding company in relation to one or more other companies means a company, okay, in which such one or more other companies are its subsidiary. And what he wanted to tell, are holding, you will be called as holding, not generally, you will be called as a holding in relation to those subsidiaries. So a holding company in relation to one or more other companies means a company in which such one or more other companies are its subsidiaries. Subsidiary company in relation to any other company means a company in which holding company does any of these two. It should do control. What control? Either control can be of two types: managerial control or ownership control. Okay, simply shareholding control. Managerial control means what? I will be called as a subsidiary company to some holding company if that holding company control composition of board of directors. If that holding company controls or exercise more than one half of total voting power, either at its own or together with one or more subsidiaries. One or more subsidiaries means what? See, subsidiary company in relation to any other company, that is to say holding company means a company in which the holding company controls composition of board of directors or controls or exercise more than one half of the total voting power either at its own or together with its subsidiaries. Okay, sir, what do you mean by composition of board of directors? Okay, you are having a power to appoint or remove all or majority of directors in the company. Means what? X Limited is having a agreement with Y Limited that X Limited can appoint or remove majority or all the directors in that Y Limited. That's all. X Limited is called as a holding company. Y Limited is called as a subsidiary company, irrespective of shareholding. No, sir. I don't have this control, but X Limited is holding 60% in Y. 60 is more than 50 or not, more than one half or not. That's all. Again, X Limited will be treated as a holding. Y Limited is called as a subsidiary. You will become holding or subsidiary either on this model or on this model, not both at a time. Okay, wow. So this is the point here. So we understood what is this. But exam two illustrations will play a crucial role. Preference share capital, whether included or not. Institute is giving multiple answers for that. I will give one conclusion. Preference capital should not be included. Okay, preference share capital should not be included. What preference share capital can be included? Convertible preference share capital should be included. Total voting power preference share capital don't have voting power. Which preference share capital will have voting power? Convertible preference share will have voting power. So whenever in the question preference capital is given, write down a note clearly. Voting power will be available only for equity, not for preference. In case of preference shareholders, convertible preference shareholders only will have voting, right? Write a note and give the answer. So equity share capital you should see. Means X Limited is holding 70% of preference share capital in Y Limited. Holding subsidiary relation don't come. X Limited is having, okay, 70% holding in convertible preference. Now what will happen? They will anyway get converted into equity in future. Again, holding subsidiary will come. Or X Limited is holding 70% of equity share capital. Undoubtedly, X is holding, Y is subsidiary. This is one point. Next, X Limited holds in Y Limited. Y Limited holds in Z Limited. X holds 70% in Y holds 70% in Z. XY are holding subsidiary. I am talking about exam type of questions, expected questions I am discussing. So X limited and Y limited are holding in subsidiary. Y limited and Z limited are also holding in subsidiary. Okay, holding subsidiary, holding subsidiary. Now the question start. What about X and Z? That is also holding and deemed subsidiary. Holding and deemed subsidiary. Why? The holding need not be direct, it can be through the subsidiaries also. It can be through the subsidiaries, not because of this point. Means the control, in the control, this control need not be directly, it can be through its subsidiaries also. And in simple language, subsidiary of a subsidiary company will be deemed to be subsidiary of the ultimate holding company. Okay, va? This is one point. Next, they can ask a question like this also. X limited is holding 70% in Y, 70% in Z. Y and Z are holding 30, 30. X is also, in A limited, X and Y holding subsidiary, X and Z holding subsidiary, Y and A not holding subsidiary, Z and A not holding subsidiary. However, X and A become holding subsidiary, not deemed. Actually, it become a subsidiary. Why? They said very clearly. Exercises or control more than one half of the total voting power, either at its own, either directly X limited should have, or through one or more of its subsidiary. Means what? Here you are holding 30, you are holding 30. I may not hold anything, but through my subsidiaries, I am holding 60% or not. Therefore, it is not a Y limited subsidiary, it is not a Z limited subsidiary, but it is a X limited subsidiary. Sir, then deemed subsidiary, when it will come? Subsidiary to my subsidiary is deemed as my subsidiary. X, Y, Z la, Y, X is, sorry, Y is subsidiary to X. Z is subsidiary to Y. Therefore, Z is deemed subsidiary to X. Here, A is not a subsidiary to Y. A is not a subsidiary to Z, but it became a subsidiary of A, not because of becoming subsidiary of my subsidiary, it became a subsidiary through my subsidiaries. Means what? Holding of subsidiaries, 30% and 30% totally became 60%. Okay, because of that holding subsidiary relation started. Okay, this is a holding subsidiary. Next one is associate company. Okay, associate company. Associate company in relation to any other company means a company in which such a company does the two things. Okay, does the two things. Again, same. Managerial control, shareholding control. Control A. So, associate company in relation to any other company, in relation to any other company means a company in which such other company, okay, such a other company, see here, has such other company has significant influence. Such other company has significant influence. Significant influence can be of two types. I can influence managerial control. I can influence shareholding control. Managerial control means how will you control? Not going to control composition. If I control composition, holding subsidiary will come into picture. So I'm not going to control managerial control completely. No composition control. I can participate in decision making. Again, I'm repeating. See, you have control, ultimate control over composition of board of directors. Means what? Appointment and removal of majority of all of the directors, you have control now. Then associate will not come. Holding subsidiary relation will come. I am not having control of board of directors, etc. Tantamari control I don't have. But my decision making will influence that company. Okay. And you are not as big as holding company, but you are having some control. Yes. Then that company is called as associate company. See, X limited, Y limited is there, yeah. Okay. X limited can participate and take decisions in board meetings of Y limited. Now Y is called as associate company. X is not associate company. This keep in mind. Example like that only they can ask questions. X is not associate. Y is an associate to X. X, see, for X, Y is an associate. But for Y, X is not an associate because Y is not holding significant influence. So therefore, holding subsidiary la parent child both side relationship is there. But associate la X, Y la Y is subsidiary to X. Y is subsidiary to X. X is not a subsidiary to Y. I'm very sorry. Y is an associate to X. That's it. X is not associated to Y. X is only investor. X is only investor. That's all. Okay? So this is one point that I have to conclude. So associate company means in relation to any other company means a company in which that other company has significant influence. Significant influence and what? Control. What control? Managerial control. What managerial? Composition of board? No. That much control I don't have, but I can participate in decision making. Okay, that's it. No. If I don't have this, still associate relation will come if that other company, holds not less than 20% of the shares and not more than 50%. Not more than 50% means what? Not a subsidiary. Not a subsidiary. Okay. See. First, holding company. Holding company in relation to one or more other company means a company in which such other company is a subsidiary company. Okay. Next, subsidiary. Subsidiary in relation to any other company means a company in which the holding company control composition of board or exercise or control more than one half of total voting power, either on its own or together with its subsidiary. Okay. Next, deemed subsidiary. When you are called as a deemed subsidiary, a company shall be deemed to be a subsidiary of holding company, even if the control is not direct, but it is of another subsidiary. Means the control is not from my company, from another subsidiary of mine the control is passing, na deemed subsidiary will come. Okay, sir, what do you mean by composition of board of directors? Composition of board of directors means you are having right to appoint or remove all the directors or majority of directors. Company here includes also a body corporate. This point not required. Next, associate. Associate in relation to any other company means a company in which that other company has significant influence, but not a subsidiary. I told this. Significant influence not less than at least 20% voting power or participate in business decisions. I told na. Joint venture is also an associate. That's it. One person company. One person company means a company in which it has only one person as a member. It has only one person as a member. By nature, one person company is a private company. But just because of the reason that it is a private company, don't tell that max the number of members is 200. For that exception is there. It is only one. Limit of one is only on members, not on directors. Over. Next, government company. Government company means a company in which not less than 51% of paid up share capital is held by central government, state government, or combination. Okay. But listen carefully. You can become a government company in two ways. Another expected question in the examination is government company. Listen. Government company expected question. You can become government company in two ways. Number one, you can become a government company through government holding or by becoming subsidiary to a government company. Roughly, I am scribbling everything. You should participate fastly. For this chapter, I gave only half an hour time. Okay, Incorporation, I will give another 40 minutes like that. Important questions we are going to cover. This marathon will change your way of understanding the exam questions. Fatafat, our target is to score 60 marks in exam. So you should concentrate on that. So whether you listen or not is entirely your discretion, but my efforts, I will not dilute. Listen carefully. Government company, now you can become government company in two ways. Either become a government company through the government's holding, or you become a government company by becoming a subsidiary to your government company. See here. Government holding means what? Not less than 51% of paid up share capital. 51% of paid up share capital should be held by central government or state government or combination of central government and state government. This is one way. So either central government or a state government or a combination should hold not less than 51%. Okay, done. 51% of what? Paid up share capital. Equity, preference, both are included here. Okay, done. That is one way. Is there any another way? Yes. Become a subsidiary to a government company. Automatically you are called as a government company. Okay. In this, they will ask one question. Okay. On that question only, exam question I am discussing. May 2016 that question came. Again in May 2024 that question came. CA Inter. So concentrate. Please listen carefully how they will ask. See, there will be a company called as X Limited. In this X Limited, they will tell Gujarat state government is holding 20%. Okay. X Limited, Y Limited, a government company is holding another 40%. Okay. Whether this is a government company or not. No, it's not a government company. I am sir. 20 plus 40 60. You said not less than 51. Fool only will think like that. Listen, you can become government company either this or this. Either government should hold not less than 51 or become a subsidiary. 40% if you Y limited hold in X limited, subsidiary anyway it will not become. 20% ki not less than 51% condition also not satisfied. Then how will you become a government company? Just don't add 20, 40 and tell 60% more than 51. Fool only will think like that. Is the answer. Okay. If you didn't understand, go back, slowly put it, listen again. Okay. I am not going to repeat. Next. Foreign company. No, I am not going to discuss here. Directly foreign company chapter will be there. Small company. The important discussion. Okay. Small company. Small company amendment came. Okay. Confusion now. What will be the answer that we need to write in exam? Okay. In recent RTP release, institute is using still 4 crore and 40 crore. So you use that only in exam. Okay, because that amendment they did not still apply for the exam. For the next item they are going to apply. So therefore, how we need to understand this? Small company means a company other than a public company. Means if you are a public company, you can never become a small company. So what should not be a small company, or who cannot become a small company? 5 companies cannot become a small company. Okay, number 1, public company, holding company, subsidiary company, section 8 company, company or a body corporate, incorporate under special act. These people cannot become a small company. So first thing in exam, what to write? What is a small company? Small company means a company other than list public company, holding company, subsidiary company, section 8 company, company or body corporate under any other act. Okay, number 1. After satisfying this, another 2 conditions are there. Okay, turnover, paid up share capital. Turnover or paid up share capital. Turnover should not exceed 4 crore. Paid up capital should not exceed 40 crore. Okay. Oh, very sorry. Reverse. Turnover should not exceed 40 crore. Paid up share capital should not exceed 4 crore. You should satisfy commonly both the conditions in order to qualify ourselves as a small company. Okay. That's the point. So actually there is an amendment in that. It became 10 and 100, but still institute is using this 4 crore and 40 crore only. Write that only in exam. No risk to be taken. But important point is, sir, paid up share capital turnover, when I should do? On the data, which date I should see? So that should be seen, the turnover as per the profit and loss account for immediately preceding financial year. Immediately preceding financial year. Next one. Another expected question is listed company concept. Which concept here? Listed company. Listen carefully. 1 minute I will disclose and discuss the concept and close this. Okay. With that, all important points will get completed. Remaining are only for your understanding. Expected questions, so those are not there. So last expected question is listed company. So let me discuss and close this. Okay. Listen to only expected questions, guess questions. Those only generally will come. At this time, don't take any risk of reading new topics. Okay. Listen to the expected guess areas. Guess areas, all important concepts I will cover. Okay. Now you are risk free. Even if a question comes other than from guess area, those are very easy. You can write on your own also. Okay. Now, so listen carefully. You can believe me completely. With the last 12 years of experience, I'm telling. Okay. You can completely believe me and continue. Okay. Listed company. What is a listed company? Listed company means a company in which the securities are listed. Shares illa, securities. This problem started. Securities la what can come? Shares can come, bonds can come, debentures can come. So many other instruments also will come. This problem. Debentures bonds ke problem started. Why? Debentures and bonds can be issued to 2 kinds of people. Number 1, public. Number 2, private. Next point, debentures will be issued for a term. Means what? I will issue debentures and list them. You will call me as a listed company and apply all listed company provisions to me. 5 years after, I will repay the bonds. Then what is the point of me complying with all those things for the last 5 years? Do you think I'm a fool? I'm muttala? Oh, is there anything written on my face? So therefore, what lawmakers said, they said, normally listed company means a company in which securities are listed. Any security can be listed. However, exceptions are there. Number 1, public companies which have not listed their equity shares on RSC, and they are not regarded as listed company. What are not regarded as? Ade exam ki important. Okay, mark my words, exam no question can come. Chance is there. Or MCQ they can ask. What is not a listed company? There is a public company. That public company equity shares are not listed, but listed their non-convertible debt securities. Okay, under a private placement. Under a private placement. What do you mean by that? They are not convertible into shares anyway. Okay, if convertible, na, very good. Shares will be converted and shares will be listed. Shares will be till perpetuity. So I will call it a listed. Non-convertible, that to debt, that to private placement. You can call it as a listed company. No. Next, not only debt security, redeemable preference shares. It is non-convertible. It will be repaid. It is a preference share, not convertible also on private placement. So public if you issue listed, 5 years also listed, it should be on a private placement. Next, private companies which have listed their non-convertible debt securities on private placement. Public companies which have not listed their equity shares on any RSE, but whose equity shares are listed on stock exchange in jurisdiction specified under 23(3) and a foreign. If you and equity shares are listed, but not in India, in a foreign exchange they are listed, then also you are not a listed company as per SEBI guideline. Follow that country's SEBI type of law, not here. So what are excluded? 3 things are excluded here. Number 1, public companies who have issued non-convertible debt securities on private placement and listed them. Second, their equity shares are not listed, but debt securities are listed. Second, non-convertible, redeemable preference shares on private placement. Okay, listed. No problem. Even though listed, you are not a listed company. Private companies, non-convertible debt securities, if they issue and list them, then also not a listed company. Last one, there is a public company. They listed their shares on stock exchange, but not in Indian exchange. Other country jurisdiction they listed. No worry, it's not a listed company. Okay, that's it. These are all the expected questions from the area called as preliminaries to the Companies Act. Next chapter, incorporation. I am going in the sequence of our syllabus. Okay, next chapter I am going to deal is like this. All expected areas I will touch and I will complete the sections. Okay, so next chapter, let us start. So we are going to start with our second chapter. Forget about the costume change. They changed. So we are now going to start with our unit number 2 or chapter number 2, which is incorporation chapter. Okay, in this particular chapter, there are quite a number of questions are there which are expected for the exams. From the question itself directly, we will understand what are all the important contents. Okay, in this chapter, first let me mark out what are important for exam. Number 1, changes. Delta. Here are representing change. What changes? Change in name, change in registered office, change in objects. First, these 3 are important points. Number 1, wherever those questions are, those questions we are going to discuss. Number 2, okay, number 2, underdogs means the last sections to the chapter 19 to 22. Okay, you will leave, they will ask. Number 3, incorporation related sections. What related? Incorporation related. Ante section number 7, 8, 9, 10A. These are all the sections. From this, questions will come in exam. Yeah, pakka question will come. Okay, so you can believe me. So let us first target on the changes. Wherever the name change, register office change, objects class change question is there, we will discuss about that and we will continue. Okay, okay, let's start. First one, first question a change. XY Limited has a registered office at Mumbai in the state of Maharashtra. For the better administrative convenience, company wants to shift its registered office from Mumbai to Pune within the state of Maharashtra. So they wanted to shift from one ROC to another ROC within the same state. Okay, but from Mumbai ROC to Pune ROC. Just now I told you what formalities company has to follow. So first listen carefully. There are 4 kinds of shifting of registered office. Place to place within the same city, city to city within the same state, ROC to ROC within the same state, state to state. This state to state illa. If state to state then we require approval of central government as well. When there is a state to state change, this ROC to ROC change, there is a procedure. Listen, simple procedure I will tell you. Whenever the shifting is from one ROC to another ROC, procedure is extremely simple. Board of directors at a board meeting has to first take a decision. This will be contained in section 179. So this point is optional to write in exam. If you write, super good. If you do not write, also marks will not be taken out. But possibly write down. As per section 179(1), board of directors of the company must take a decision on shifting of registered office from one ROC to another ROC. Next, shareholders special resolution in a general meeting. Okay, this you should form a sentence. Company should obtain the approval of shareholders by passing a special resolution in a general meeting. Number 3, Connected provision also you can quote. What is that? Whenever company passes special resolution under section 117, you have to file form MGT 14 with ROC within 30 days. This is the optional point. If you write super good, you will be the only student who will quote these interlinks. Okay, crossovers. Number four. Obtain the approval of RD. Obtain the approval of what? RD. How to obtain the approval of RD? There is a procedure. See here. Company must apply to RD. When you apply your wish, RD, okay, RD has to give his confirmation, to the company within 30 days. Company has to file the confirmation copy with the ROC, okay, within next 60 days. ROC have to note the confirmation and issue new certificate of incorporation with the new registered office within next 30 days. So 30, 60, 30. 30 is for what? RD to company. 60 is for what? Company to ROC. 30 is for what? ROC back to company. Okay, what? This is the procedure. Since this question is a 3 marks question at the time when they tested, this is an exam question, 3 marks they asked. Therefore, answer given by the study material or answer given by the ICA is not fulfilled. Means complete answer they did not give. But I answered for a 6 marks question. So if a question comes for 6 marks, now first write down, company has to obtain the approval of board of directors by passing a resolution at a board meeting, shareholders by passing a special resolution at a general meeting, file the special resolution copy under section 117 in form number MGT 14 with ROC within 30 days of passing the special resolution. Next one, company has to obtain the approval of RD. Obtain the approval of RD has a procedure. The procedure is as follows. Company has to obtain the approval of RD by making an application. RD has to give his confirmation whether yes or no within 30 days. File that confirmation copy with ROC within next 60 days. ROC has to issue a certificate of incorporation with the new ROC within next 30 days. Sir, question came for 3 marks. What I have to write? You have to write everything, but this procedure you need not write. Directly write down, obtain the approval of RD. That's it. See the answer. I am giving you only 30 seconds of time. This chapter is not like preliminaries. You should first apply the mind. Every answer I will give half a minute time for you to read. Beyond that, pause the video and see. So since state to state change does not happen, it does not result in alteration of memorandum. So memorandum alteration not required. Why memorandum alteration is not required? Because memorandum of association contain the name of the state. State change ke this will happen. Since state is not changed, it's not required. Okay. So first thing, I told na, board of directors, they do not quote in the answer. You have to write in exam for a better presentation. First special resolution, obtain the approval of RD, regional director. Okay, ba? Next question. Next. First, I will cover all the changes questions. Change in name, change in objects, all those first. Question number 9. This is also on name clause only. So first we are going to cover all the clauses. Name, situation, objects, capital and liability, and what to say, capital clause and liability clause. But I'm not going through capital and liability because in share capital chapter we will read that. Mainly 3 things: name, objects, and name, situation, objects. Here name clause. Again, there is a rectification question. Let us read. Hey, during the question itself, we are going to cover the concept as well as the answer. Rather than reading in a concept, we are going to read the concept along with the expected questions in exam. So you are on par with the standards of the examination. Okay, va? Please participate. 60 is our target. Okay, va? Manglu and Friends got registered a company in the name of Taxman Advisory Private Limited. Taxman is a registered trademark. So they got the company in the name of Taxman Advisory Private Limited. But Taxman is a registered trademark because Taxman Publications is there, a company, a particular brand is there. There is no Taxman company. There is a Taxman brand. But here is a Taxman company they incorporated. After 5 years, when the owner of the trademark came to know about the same, it filed an application with the relevant authority. Can the company be compelled to change its name by the owner of registered trademark? Can the owner of registered trademark request the company and then company changes its name at its discretion? Super question. Let me first discuss about the section. This is section number 16. Whenever there is a change in the name of a company, change in the name can happen in different ways. I can voluntarily change, or I can go on rectification change also. Listen first. Whenever ROC by mistake, by inadvertence. Inadvertence means without knowing about the consequences. Okay, by mistake, if ROC has incorporated any company with the name which is already similar or identical to the name of an existing company or a trademark, existing company or a trademark means what? If a company is incorporated with a name which is too similar or same or identical to the name of an existing company or an existing trademark. Okay, we are now going to talk about trademark. First exam law, you have to write about the provision in the law. So as per the provisions of section number 16, if a company got incorporated with a name which is similar or identical or too nearly resemble to the name of an existing company or a registered trademark, okay, then the company who has the resemblance, the other company is there now, who has that resemblance has to apply to the central government to ask for the change in the name of the company. But there is a small twist here. There can be a company whose name is similar to another company or similar to a trademark. If it is similar to the name of a company, time limit is not there. But if it is similar to the trademark, there is a time period of 3 years. There is a time period of what? 3 years. 3 years from what date? 3 years from incorporation of first company. 3 years from the trademark registration. 3 years from incorporation of new company. 3 years from the incorporation of this new company. This particular owner of trademark, proprietor of the registered trademark, within 3 years from the date on which the new company is registered, which is similar to the name of that particular trademark, has to make a complaint to the central government. If central government also felt that yes, really this is similar, leading to confusion, they will ask company to change the name by passing ordinary resolution within 3 months. But what happened in this? First you have to write for, this question came for 6 marks. 3 marks you first have to write the provision. Then discuss the case properly. In the given case, taxman trademark, the proprietor of the taxman registered trademark applied to central government after 5 years, which is beyond the 3 years time limit as given in the section number 16. Therefore, application made by taxman to the government is not maintainable. Means the new company with the name taxman need not change its name. However, I am the registered trademark owner taxman. I went to taxman company and I said, sir, you incorporated today, okay, or you incorporated 3-4 years. I was there from last 20 years. Please, can you please change? You request. Who requests? Taxman trademark owner will talk with the taxman company. And if taxman company is agreeing for that, there is a genuinity in the argument, then they will voluntarily go for change in the name by following provisions of section 13, by passing a special resolution and changing the memorandum of association. In that, name clause will be altered. So that answer that they have given. See, if a company is registered with the name which is identical with the name of a registered trademark, the company, then the central government will ask to change by passing ordinary resolution within 3 months. Okay. But if it is identical to the registered trademark, within 3 years of incorporation of the new company, it may direct the company to change its name. The company shall change its name by passing ordinary resolution within 3 months. Okay. Main point is filing an objection after 5 years, okay, with a wrong name, while it should be filed within 3 years. Therefore, company cannot be compelled to change the name. However, what they can do, company can change it voluntarily by following the provisions of section 13. Okay, va? Next question. Again, question number 10 is also an alteration only. Let us see. The objects clause of memorandum of Vivek Industries Limited empowers to carry real estate business and any other business that is allied to it. Due to downward trend on real estate business, management of the company has decided to take up the business of food processing activity. So from real estate to food processing, they wanted to go. Okay. Company wants to alter its memorandum to include food processing. Means they don't want to close the real estate. They wanted to add a different business, which is a food processing business. Examine whether the company can do so. Okay, well, read the question. Listen, I wanted to just discuss. It is gone. Now see here. So what I wanted to just discuss 2 points here. See here. Whenever objects clause change is there, first procedure number 1, board of directors at a board meeting, alteration of MOA, take the approval of shareholders by passing a special resolution in a general meeting. Special resolution is passed in a file form MGT 14 within 30 days with ROC under section 117. Okay, 4 points you have to write here. Whether it is there in this answer sheet or not, please remember to write this. This is as per section number 179(1). This is as per section number 13 subsection 1. This is also as per section 13 subsection 1 and subsection 2. The fourth one is as per section number 117 subsection number 1. Okay, well, these are all the sections you need to quote first. Okay, so obtain the approval of board of directors by passing a board resolution in the board meeting. Alter the articles, alter the memorandum by passing a special resolution in a general meeting by taking the approval of shareholders. File the special resolution copy with the ROC within 30 days of passing the special resolution under section 170. Write down this. Okay, first you have to write these 4 points. Okay, this is a value addition point. Remaining will be there in the answer also, sized answer as well. Next, now come to the case, not case law, given case. They are into real estate. Now they wanted to shift themselves into food processing business. Okay, so they wanted to change the business nature now. Okay, they wanted to change the business nature. So they can change by passing the special resolution, all this procedure. So now the Vivek Industries wanted to alter its memorandum by changing the real estate business. They wanted to include food processing. They can do so by following the procedure above. For that, you will get the 4 marks. Okay, see the answer. Alteration memorandum is governed by is more flexible. Section number 13(1). Special resolution. I told na board meeting they don't give the point here. You write in exam without forgetting it. File the special resolution with the registrar. I told na section 117. That point they included. Okay, and when you change the objects, ROC has to give new memorandum na registration after. They have to register new memorandum. So therefore, certify the registration within period of 30 days. It is the obligation of ROC. So ROC has to certify the new memorandum within 30 days. Okay, and unless and until ROC registers, new memorandum will not come into effect. So Vivek Industries can make required changes in its memorandum. Next question 11. Anushka Security Equipments Limited, creativity of ICIC. Anushka Security Equipments Limited is a manufacturer of CCTV cameras. It has raised 100 crores to the public issue of its equity shares for starting one more unit of CCTV camera manufacturing. It has utilized 10 crore and then it realized that the existing business has no potential for expansion because government has reduced the customs duty on the import of CCTV camera. Hence, imported cameras from China are cheaper than own manufacturing. Now it wanted to utilize the remaining amount in the mobile application development business by adding new object into the memorandum. Does the Companies Act allow such change of objects? If not, then what advice will you give to the company? If yes, then what steps to be followed? Super question. Pause the video. I'm also pausing it. Pause the video and read the question first. Okay. So using this question, we are going to understand another point. See here. This question is based on section number 13 and another section in Prospectus chapter also section 27. This is similar. Okay. So we are covering here itself. What is the point here? There is a company. There is a company which is a public company, which is a listed company. Public issue it went, raised money and money is still unutilized. At the time it wanted to change its objects. What is the procedure? Then they said the following is the procedure. Okay. Number 1, decision has to be taken by the board of directors at a board meeting. This is implied under section 179(1). Later, alter the memorandum of association by taking the approval of shareholders by passing a special resolution in a general meeting. This is as per section number 13, subsection number 1, read with other subsections. And number 3, file MGT 14 along with special resolution copy within 30 days with the ROC under section 117(1). Number 4, very important. For a company which is a public company, which is a listed company, went for public issue by raising money which is unutilized and it wanted to change objects. In this case, since it's a listed company, public at large has to know about the alteration. Therefore, advertisement you have to give in 2 places. 1, newspaper, second one website. How many newspapers? Two. One in English, another one in the local vernacular language, and also in the website. Sorry, what advertisement I have to give? Advertisement about what? Advertisement about, okay, change in the objects and justification. And what? Justification. And what you are changing, why you are changing, justification. And very, very important, also advertise about exit offer. What offer? Yeah, exit offer. What is exit offer? Special resolution you are passing now in the step number 2. In the special resolution means 100% approval. No, yeah, votes cast in favor should be 3 times more than votes cast against. And if, for example, 100 people went to the meeting, 25 voted against, 75 voted in favor, resolution is passed. This 25 people are called as dissenting shareholders. Shareholders, dissenting shareholder. To these shareholders who do not like this alteration, you can't force them to stay. Give exit offer by paying in cash and send them out of the company, because they don't want the company to carry those objects. Okay, that's the point. Last one, ROC has to certify the change and give fresh certificate of incorporation. This is the project. These are all points you have to write in exam. Okay, so first point number 1, board of directors by passing a resolution at a board meeting, altering the article, altering the memorandum of association by pass, shareholders should pass a special resolution at general meeting, file the copy of a special resolution along with form number MGT 14 within 30 days of passing the special resolution with the ROC under section number 117 subsection number 1. And the next one will be given advertisement in the newspaper and also on the website. When it comes to the newspaper, it should be in the 2 newspapers, one in English, another one in the local vernacular language. And finally, the advertisement should clearly mention that the objects are being changed and the justification for changing the objects. And very, very important thing is, you should also intimate about the exit offer that you are going to give to the shareholders of that particular company, and the exit offer paying the cash, which will be decided by SEBI by the guidelines provided thereunder. And finally, ROC has to certify the change and issue a certificate of incorporation to the company for the change in the objects clause of memorandum. Answer completed. Hey, listen careful, I will not repeat. Okay, now one tadava sonnana, 100 tadava sonna madiri. Listen carefully, one time only I will repeat. Next, 11 over. Next, if there is any change in objects, etc., we will discuss. Okay, no questions are there. Study material questions completed. Now let us come to past papers. Hey, you know how the style of our question bank, na? First time in India, we divided the questions into 4 parts. Study material questions, past paper questions, RTP questions, MTP questions. Okay, such that question bank will be literally used for its real purpose. First, study material questions will complete. Next, we are coming to past papers. In exam, how the questions are being tested, let us see. Yes, question number 3. Examine the validity of the following decisions or proposals regarding the change in the office by A Limited under the provisions of Companies Act. Register office is shifted from Thane, local limits of Thane district, to Dadar, local limit of Mumbai district. Both places are falling within the jurisdiction of ROC Mumbai by passing a special resolution, but without obtaining the approval of regional director. Okay, first let us discuss on the point 1. Where you are changing from one place to another place within the same limits. Within the registrar of Mumbai only you are changing now. It just require board of directors board meeting, though they do not write here, you write in exam. I am telling 100 times. Okay, sized answer these fellows did not give. But actually, without board decision, to pass a special resolution, first a general meeting has to be called. General meeting has to be called means idea should come. The agenda has to be prepared by board. And the first board of directors has to first approve it or not. So that's why I'm telling you, please, though they do not give in the sized answer, you please remember, pass a board resolution by passing a resolution at a board meeting under section 179(1). You write that. Don't forget about this point. So first point, board of directors at a board meeting, they have to pass a resolution, take a decision under section number 179 subsection number 1, irrespective of whether it is given in sized answer or not. Number 2, since the change is between one place to another place within the same local limits, nothing, RD approval not required. Just you have to pass a special resolution in a general meeting. So board approval, special resolution. Copy of special resolution has to be filed with ROC within 30 days in form MGT 14 under section number 117. Okay, ROC will register the changes accordingly. See, same ROC is there. Special resolution is required. No approval of RD proposal is valid. Okay, first question over. Second bit, register office is situated in Mumbai, okay, within the jurisdiction of ROC Mumbai, whereas corporate office is situated in Pune, Maharashtra state, within the jurisdiction of ROC Pune. Okay, A Limited proposes to shift its corporate office from Pune to Mumbai under the authority of board resolution. See, I told you this institute is dangerous. Yeah, they don't give in size to answer, but they give in the question. Understood? Why Koushik Mukhesh is always vigilant when it comes to ICA exams? Na? I'm really always vigilant. And when I discuss something in the class, I will discuss so many things. Na? My reason is very clear. Like the professional exam, they expect a student to have a minimum common sense. Without that, we should not go to exam hall. So just blabbering in this marathons is not the point. Na? We have to give proper content even a day before examination. Okay. Sir, what is the difference between registered office and corporate office? Registered office is as per Companies Act. Corporate office is for administrative convenience. It is not covered by Companies Act. Corporate office is different. Registered office is different. Registered office, na, all your books of accounts will be kept there. Registered office, na, ROC records, that address will be there. Corporate office means what? For example, I am from Hyderabad here. Okay, I am from Hyderabad. Obviously, when I was from that particular place, I want my registered office to be there. Okay, I want my registered office to be set up in my place where I am from. Okay, or let us say, for example, I wanted to put my registered office in Vijayawada. Okay, Vijayawada, I wanted to put my registered office. Sorry, I will put my registered office in Vijayawada city. But rather than Vijayawada city, I wanted to have my registered office in a metro city like Hyderabad, Chennai, like this. The two cities where I am, I will be really having a natural love towards professionally through Chennai or from Hyderabad. If you call, now these two cities are there. Now I chosen. So I will put my registered office in Chennai or I will put my registered office in Hyderabad. I decided. Corporate office is different, registered office is different. Registered office is sentiment out of it, people will put. But corporate office is for reachability, accessibility. People should reach that place. That is nowhere governed by Companies Act. Therefore, you put your registered office, corporate office anywhere. See what they are saying. A Limited proposed to shift its corporate office from Pune to Mumbai. Shift it, no problem. Her Companies Act do not apply. Directly, board of directors only can take a decision. Next, let us see the answer. Section 12 talks about shifting of registered office only. In the second case, corporate office is being shifted. Okay, shifting of corporate office under board resolution is valid because section talks only about registered office shifting, not about this. Okay, va? Okay. Next. Third question. Registered office is situated in certain place of a city, is proposed to be shifted to another place within the local limits of the same city. See, my registered office is located in T Nagar. I wanted to shift it to Nungambakkam. Within the same city, all these things, nothing will happen. Board resolution is enough. Special resolution also not required. Under the authority of board resolution, yes, you can do. So third case, changing registered office within the local limits of the same city, board resolution is valid. See, board resolution is valid, they are saying now. And a board resolution is required for every change. That point they do not quote anywhere. That is as per 179. That's why I'm asking you, every student, please listen. Though they do not give in the size answer, you write down clearly. First, board resolution is required. Okay, well, I hope everyone understood this point also clearly. So let us continue with another question. Question number 10 from the past exam questions again. Okay, this was also tested in the examination for 7 marks. So let us see the question. UINA Infra Projects Private Limited was incorporated on 1st June 2022. Mr. X had already registered the trade name. Okay, UINA Infra Projects on 1st April 2018 under the Trademarks Act. So name of the company UINA Infra Projects Private Limited. UINA Infra Projects is a trade name registered under Trademarks Act. Mr. X was suffering from a prolonged disease since 1st April 2021. When Mr. X recovered from the illness on 20th May 2024 and joined his own office on 5th July 2024, he came to know from his staff members that a company has been incorporated with the name of UINA Infra Projects Private Limited. He lodged a complaint with the regional director on 10th July 2024, requesting him to order the company to change its name. The regional director examined the application of Mr. X on 11th July 2024, issued a direction to UINA Infra Projects Private Limited to change its name. Mr. D, the director of UINA Infra Projects Private Limited, contended that above direction of the RD was bad in law and therefore not proper on the following grounds. Number one, why the company is saying that we will not change the name? So reason number one, the name of the company is not too identical with or too nearly resemble in the name of any other new company. any other company, that the stipulated time period of 2 years of making any complaint with respect to the name has already been over by 31st May 2024. Referring to the applicable provisions of Companies Act, decide whether the contention of Mr. D is tenable. Also advise UANA Infra Projects Private Limited the period within which the company will be required to change its name in case of the direction of regional director was valid. Super question, means entire section 16 was revisited again. Already we discussed in the section number 16. Again, I am not going to discuss and waste our time. I will just give the conclusion, what to write. Okay, read the question, pause the video, spend 2 minutes time, read the question first. Okay, read the question. Okay, see here. What happened in this question? Same story again. UINA Infra Projects Private Limited was a company incorporated on 1st June 2022. There is already an existing trademark in the name of UINA Infra Projects, which was registered on 1/4/2018. So this trademark was registered even before registration of your new company, correct? So therefore, what this proprietor of the trademark should do, he should apply to the central government significantly. RD, he should make an application within 3 years from the date of incorporation of company, not from registration of trademark. So 3 years means 1/6/2. Okay, 1/6/2, next to 1/6/2023, 2024, 2025, till then, till 31st May 2024, he is having time. 22 to 23, 23 to 24, 24 to 25. Sorry. Okay, he is having time till then. So 22 to 23, 1 year, 24, 1 year, 25, another year, 3 years time is there. Now let us see the contention. First thing, that the name of company is not identical to the name of any other company. Need not be. Section 16 will say rectification is required to be made by the company upon application, not only by the company name which is having similarity, also by a trademark name. On that they said. So contention of Mr. D, the director, is valid or not valid? Not valid. Okay, next. Stipulated time of 2 years. Are 2 years? 3 years. Okay. So it's a 3 years time. 3 years from the date of registration of company with the name which is identical to the name of a trademark, within 3 years from that date. Okay, well? So same. First you have to write the entire answer. Section 16 means if ROC by inadvertence or by mistake, if he registers the name of a company which is similar to the name of an existing company or a registered trademark, then either on their own or on an application made by the proprietor of the registered trademark, he will make a change by passing ordinary resolution within 3 months. Okay, well, so all those things you have to write within 3 months. Everything we have to write. Finally, the conclusion. Part 1. First ground of objection. Okay, first ground of objection. So registered trademark. So Mr. D is not tenable. Means the argument of D is not tenable because similarity need not be only with the company's name, also with the trademark name. Next, second ground of objection. The contention of Mr. D is not tenable. The application should be made by proprietor of registered trademark within 3 years from the date of incorporation. Yeah. Okay, so we completed some questions relating to the alterations, but all alterations are not given in exam. So just I will cover fastly from the charts also. Okay, place to place within the same city, board approval, shareholders approval not required, and alteration of memorandum not required, special confirmations also not required, central government approval not required. Duty of ROC, just register the change. Over. 7 steps. When I want to change from one place to another within the same city, city to city within the same state, then board of directors at a board meeting, shareholder special resolution, no alteration of MOA because state is not changing, no special observations or confirmations, and central government approval not required, and ROC shall register the change. Next, ROC to ROC within the same state. This is important. So board of directors at a board meeting has to take a decision. Shareholder special resolution mandatory, and alteration of MOA not required because state change is not there, only ROC change is there, but RD confirmation is required. Steps are there. I already written na, company should obtain to the RD 30, 60, 30. So RD to company 30, company to ROC 60, ROC to company back again in 30 days. Next, central government approval not required, and final touch is state to state. This requires memorandum alteration as well. So board of directors at a board meeting, shareholders by passing a special resolution in general meeting, memorandum alteration is required, and no other conditions or specifications are attached. Central government approval is required. But how that central government approval has to be obtained? See here. Company has to apply for, okay, company has to apply to the central government. Central government will issue approval to the company within 60 days. But there are three conditions. Any of the three conditions, either this or this or this, you need to satisfy. First, you are changing from state to state, na? There is every chance of doubt on you. Therefore, condition 1, take the consent of creditors or debenture holders. Sir, consent they will not give. In that case, at least to prove to the government that you have made sufficient provision for making the payment to them. Okay. No, sir, provision also not great. At least show that you are having sufficient assets, security to the debts such that you will discharge them. That means you are not a cheater. Prove that. Next, then central government confirmation will be submitted to the ROC of both the states. ROC, in this case, ROC of the state to which RO is shifted and a new state shall register the change and issue for a certificate of incorporation. That's it. So name clause, nothing great. Name clause alteration just required board approval, shareholders approval, copy of special resolution has to be filed with ROC and ROC has to register. So nothing great. Only rectification of name is important, that already we have covered. Okay. So expected areas in questions la, first change in name over, registration over, objects over. Next 19 to 22. In this set, we are going to cover the questions now. Okay, let us start. Yes, 19 to 22, the second question only 22 is there. Parag Constructions Limited is a leading infrastructure company. One of the directors of the company, Mr. Parag, has been signing all construction contracts on behalf of company for many years. Because company is an artificial person, company cannot sign. All the parties who ever deal with the company know Mr. Parag very well. Company has got a very important construction contract from a renowned software company. Parag Constructions will do the construction for the site in the partnership with local contractor Firoz Bhai. Mr. Parag signed partnership deed with the Firoz Bhai on behalf of company because he has an implied authority. Later in a dispute, company denied to accept the liability as a partner. Can the company deny its liability as a partner? Is a question that is being asked. See, rather than discussing the charts, I am going to discuss the concept through the exam question itself, such that you will understand the wavelength of the institute first. And blindly, rather than reading the concept, you will read as per the expectations, how the questions will come in exam. Okay, ba? Read this. Question number 2. Pause the video, read the question first. Later answer. Okay. Read the question, listen carefully. No repetition. Okay. One time only I will tell, listen carefully. There is a section called as Section 22 in Companies Act. 22 has two parts. Okay. Limb 1 will be talking about negotiable instruments. Who can execute on negotiable instruments? Company is an artificial person. Hands, legs will not be there. It can't come and sign. So who should sign on behalf of company on the negotiable instruments? Means promissory note, bill of exchange, check, somewhere. Who has to sign? So in that case, what they said, na, any person having implied authority within the company can sign. What I said? Negotiable instruments, bills of exchange, check, all these things. Who can sign on behalf of company? Any person having implied authority within company. Sir, please tell me what do you mean by implied authority? Implied authority means I need not tell you have authority. Okay. Generally, by your duties, I can generally assume that you are having that authority. For example, finance department is there. Okay, cashier is there, or cash dispatch department is there. What is the purpose of that department? Checks signing, all these things they only will do. Directors of the company, they are the persons working on behalf of company. Company is an artificial persons, na? Who will work on behalf of company? Directors. So generally directors are assumed to have an ostensible authority, and I mean in implied authority is generally assumed to have with the director. So even though when you open the articles or any agreement, even though when you open any articles or any kind of agreement, even though you do not find any director's name and who should sign on a check, they may not write. Any director, any person within the company having implied authority, that does not mean company is there. Okay, one typist is there. Okay, type worker. That person cannot come and sign because you don't expect to have an implied authority for him. Watchman cannot sign. You are not expecting to have a implied authority. Director, so accounts manager, or cash dispatching department, like that you need to understand. So what I said, 22 has two limbs. Limb number 1 is negotiable instruments limb. Any person having implied authority can sign. Second one is a deeds, partnership deed, sale deed, lease deed, gift deed, like this. Any deed signing, na, implied authority person cannot sign as per section 22. Only the person authorized by the company is having company secretary, na, CS and one director has to sign on authorization. Means what? They have to write an authorization document saying that, see, R. Koushik Mukhesh, executive director, he is having right to sign on deeds on behalf of company. Only that person has a right. if company has a CS. Sir, company la CS not there, sir, then at least 2 directors will sign on the authorization deed. Again, I'm repeating, don't do mistakes in exam. 2 directors will not sign. If company has a company secretary, that company secretary and a director will prepare an authorization deed, an authorization document, authorizing a particular person as having a right to sign on deeds. That person only should sign. Here, who are that CS and director? CS and director will not sign on deed, will give power to a person to sign on deed. If company don't have CS, now 2 directors will do that. Okay, which section said like this? 22. That's why I'm telling you, they will ask in exam. Okay, see. As per section 22, company may authorize any person as an attorney and agent to execute the deeds on behalf of company. Okay, if company has a common seal, no problem. But company common seal should be affixed on the authority and should be signed by 2 directors. Okay, 1 director and 1 secretary. 1 director and 1 secretary. If company secretary not there, 2 directors, or else 1 director, 1 secretary has to sign. The deed signed by such authority under common seal, okay, on behalf of company and under the common seal shall bind the company. In the present case, company has not either given written authority, not affixed a common seal of the authority letter. It means Mr. Parag is not legally entitled to execute the deeds. Simply in section 22, I will show you how it look like. Okay, execution of bills of exchange, promissory note, any negotiable instrument on behalf of company, any person having implied authority can sign. But a deed can be signed if company has a common seal. If company has a common seal and a stamp is there, any person acting as an attorney under the seal, okay, can sign. Means, for example, there is a common seal. There is a common seal. When common seal is there, any person having right to affix common seal can sign. Company do not have common seal, any person authorized by, if company has a CS, director and CS. If company don't have CS, 2 directors have to sign. So common seal is there, no worry. Any person who is having right to affix common seal can affix common seal and sign. Or else director and CS, if CS not there, 2 directors have to sign on deeds. Okay, in the given case, what happened? Mr. Parag signed partnership deed with Feroz Bhai because he has implied authority. No, implied authority will work only in case of negotiable instrument, not in case of deeds. 22, 1 question is completed. Next, section 20. Explain the provisions of Companies Act relating to service of documents on a company and members. A direct question. So I will cover this one. Any other new question in section 20 is there? Just you can revise and you can leave. So first section 20 I will tell you. Okay, okay. Now listen. 20. Anyway, direct question. I will directly show you the charts. See here. Listen carefully. 2 minutes I will discuss on this. Service of document. What is the service on document? In this section, you are going to learn about place where to send a document. Place where to send a document. Document or communication or process or notice or something you wanted to communicate. Where to communicate. Okay, depending. See, 2 things we have to understand. In this section, again 2 limbs. Communication by someone with the company. Communication by company with someone. Repetition again. Communication by someone with the company. Communication by the company with someone. 2 discussions we are going to see in section 20. First, communication of others with the company. Okay. See, point number 1. If you wanted to communicate with the company, company is a separate legal person. It is having its own legal address. A legal address we call registered office. So, if you wanted to communicate with the company or with the officer of the company, see, when I say officer of the company, you are communicating with him in officer of the company capacity, not in his personal capacity. Example, they can ask a question like this. Koushik Mukhesh is a director of a company. Director is an officer. Okay. You wanted to communicate with Koushik Mukhesh in his capacity as a director. Okay. Or second, my parents wanted to communicate with me through an official documentation. Okay, then they will send to my house address, not to company address. But if they wanted to communicate with me in capacity as a director, send to the registered office of the company. Okay, so you are not communicating with KM in his KM capacity. You are communicating with him in a officer capacity. So send it to the registered office of the company only. Okay, so communication by third party with the company. Okay, where to send? RO. How to send? Either register post, speed post, courier, hand delivery or electronic mail. Okay, done. Next, now important. Company wanted to communicate. This communication to the company by third party. The communication by the company to third party. Now company wanted to communicate. Communicate to whom? Communicate with ROC or member. Okay, that means company wanted to send a reply to ROC, or company want to send a general meeting notice to member. Okay, both examples I told you. In this case, where to send? If it is ROC, at his office. If it is member, at his address. Okay, how to send? Post, registered post, speed post, hand delivery, courier, electronic means. But very, very important one point. If a member says very clearly that I wanted only through speed post or through registered post, because some old members will be there at age 70, 80 like that. They don't have emails, etc. They will specifically tell a company, if you wanted to communicate with me, communicate only by registered post. Okay, if traditional way of delivery they require, you can ask, but you have to pay the fees for that once in a year. So member may choose any particular mode upon payment of fees as decided by AGM. This is what discussed in section number 20. So question 3 also completed. Just a minute. You pause the video, read the answer. Okay, I'm not going to give any extra time. You pause the video and read the answer. Hopefully you read the answer. Okay, I'm not going to give any extra time. So next important question. Section number 19. 19 to 22 I said na. 19th section one question came. Okay, first I will tell about 19th section, then we will read the question. Okay, section number 19. Subsidiary not to hold the shares in holding company means what? Once you become a subsidiary to a company, subsidiary should not hold the shares in holding company. Okay, what is the general prohibition? A subsidiary shall not hold the shares means subsidiary cannot purchase the shares of its holding company. Then what they will tell? Okay, you will not purchase. Can they allot bonus shares to you? No. Holding companies shall not allot or transfer shares to the subsidiary company. This is general. But there is an exception to this. What is the exception? 3 exceptions are there. Exception number 1. What is that? Exception number 1. For example, see the screen. See the screen. Fastly I will tell you. See the screen. X is a member of a company. X is a member of a company. This X made nominee. Nominee means if X die, share should be transmitted to whom? This nominee happens to be Y Limited. Okay, X is a member of X Limited and his nominee is Y Limited. Nominee can be anyone. Okay, nominee should be a legal person. Company is a legal person. So therefore, nominee can be Y Limited. So company is X. X is a person, member of X Limited. He has a nominee Y Limited. Okay. Okay. Now what happened? X died one day. Okay, X died. Once X die, what will happen? All the shares in X Limited will go into the hands of Y Limited. Now the twist is Y Limited is a subsidiary to X Limited. Subsidiary to what? X Limited. And now what is happening? Y Limited is now holding the shares of X Limited, being the person who is getting the transmission of the shares or not. So now what is happening? Y Limited, which is a subsidiary company to the holding company, is now holding the shares now, being the shares are getting transmitted. But you should not hold means you should not hold. But here, Y Limited is not holding the shares. Legal representative capacity, Y Limited is holding the shares. Y Limited is not purchasing the shares out of its money. Kada. Here, I am holding not in my own capacity. I am holding in capacity of a dead person called as X. Now this is called as a legal representative of a deceased member. Legal representative of deceased member. This is valid. This is valid. Okay, next. One exception completed. Second exception. See, there is a trust. There is a trust. Trustee happens to be Y Limited. Trustee happens to be Y Limited. Now, Mr. A is a shareholder of X Limited. Mr. A is a shareholder of X Limited. He is the author to the trust. I will not repeat. I am telling you very clearly. If you listen, that's all. So A is a shareholder of X Limited. A created a trust, different trust. Okay, he is the author. Now A have to transfer the properties in the favor of trust. Na? He transferred these shares to trustee called as Y Limited. Now answer, Y Limited is holding the shares or not? You said that once you become a subsidiary, Y Limited is a subsidiary to X Limited. If you become a subsidiary, you should not hold the shares. No worry. Even though you become a holder, you are not holding in your own capacity. You are holding in the capacity as a trustee. This is rende exception. So what is the first exception? Legal representative of deceased member. Second, trustee to the trust. In these two cases, you are not holding the shares in your name, you are holding the shares in others' name. Just as a representative, you are holding. Therefore, voting rights will be given, dividend also will be given to you. However, third exception important. Okay, see, X Limited, Y Limited. X Limited holds 70% shares in Y Limited when on 31st of August 2025. Okay, now Y Limited purchased 10% of the shares in X Limited on 1st June 2024. And 1.5 year back, Y Limited held the shares in X Limited. And before the relation of holding subsidiary started between X and Y, Y already purchased 10% of the shareholding in X Limited. On 1/6 they purchased. Okay. Later on, after 1 year or 1 year, 3 months after, you are acquiring the shares. In this case, also okay, no problem. Why? Because I am not getting allotted with the shares after becoming a subsidiary. I am not holding the shares after becoming a subsidiary. Even before becoming a subsidiary, I have done that. This is an exception that operates in favor of the Y Limited. However, in the first two cases, shares are not held in your name. Others' name got to you. But in this case, whether before or after acquisition, in your name only you purchase, voting rights will not be given. That's it. Answer is over. Okay, va? So, legal representative, deceased member, shares held as a trustee, shares held even before it became a subsidiary. Voting rights available, voting right not available. Charts, if you read properly, full clarity. Sorry, anyway, let us see the answer now. Okay, in accordance with section number 19, okay, subsidiary cannot hold the shares in holding company. Exceptions. Subsidiary can hold the shares in holding company as a legal representative of deceased member, as a trustee, become a shareholder even before it became a subsidiary. Answer over. So 19, 20, 22 over. 20 life question is there, I will discuss. If question is not there, why I will discuss unnecessarily. See, on the same section 19, another question also came in exam. If there is a question, I will discuss. Undoubtedly, I will discuss. Just I will check now. If there is any exam question, yes, section 20. Articles of Association of AB Limited provides that documents may be served upon a company only through a speed post. Suresh dispatches some documents to the company by courier under certificate of posting. The company did not accept it on the ground that it is in violation of AOA. As a result, Suresh suffered from loss. Okay. Now, section 20, what it said, any third party wanted to communicate with the company, they can communicate with the company at the register office of the company, either by post, speed post, registered post. Okay. See here, just now we discussed, you should not forget. Okay, see, communication to the company, registered post, speed post, courier, hand delivery, electronic means, all are allowed. Okay, what this company is saying, only through speed post. Wrong. Speed post also is there. Speed post only illa. Okay, courier is also valid. So courier is there. It is valid. Whether refusal of document by the company is valid? No, not valid. Pakka. That's what. And Suresh can claim damages? Yes, he can claim damages. You know the concept, 2 minutes you will write. Again, section 19, all these things only. Great. The definition. First chapter we already completed. On that only I kept here itself. That's it. Yeah, nothing greater. So section 19 completed, 20 completed, 21 questions not there, 22 completed. So 20, instead of leaving it all together, let us read what is there. Authentication of documents, proceedings and contracts. Okay. See, authentication of and execution of bills of exchange, negotiable instruments completed, deeds completed. Other than negotiable instrument, other than deeds, any documents or contracts are there. Then who will sign? See, any document, proceeding or a contract which require authentication of company shall be made on behalf by KMP or officer or employee authorized by the board. Next. So in our targeted questions, what are there? Yeah, what concepts we completed? Our target is we have to complete those. So 19 to 22 also completed. Next, 7, 8, 9, 10A. Main 7, 8. 7, 8, whatever questions are there, let us try to cover. I will cover such questions came in exam which covers everything inside section number 7 and 8. So question number 7, which is on section number 8. A group of individuals intended to form a club, namely Building Pilots Flying Club, as a limited liability company to impart classroom teaching and aircraft flight training to the trainee pilots, education related. Okay, it was decided to form a LLP, limited liability company for charitable purpose under Section 8 of Companies Act for a period of 10 years. And thereafter, the club will be dissolved and the surplus assets over liabilities, if any, will be distributed among the members as a usual procedure allowed under Companies Act. Examine the feasibility of the proposal. Pause the video, read the question. Hey, we are just 2 steps away from completion of this chapter, because after 8, I will cover 2-3 questions on Section 7. 2 questions on Section 8, 2 questions on Section 7. We will cover, close this area, we will go to the next chapter. Okay, so please attentively read the question first. We are just 1 step away from completion of this chapter. Okay, read the question, listen carefully. Okay, first what happened now? See, there are some group of people. They started one club, which is a aircraft training club, non-profit company. Okay, so they decided to form a company under Section 8 of Companies Act. They wanted to continue the company for a period of 10 years. After 10 years, they wanted to dissolve. Surplus will come now, that will be distributed among the members. They are asking advice. Wrong. They cannot do. Reasons I will tell you. Okay. 2 things you have to write in exam. First, write down what is a Section 8 company. Section 8 company is a company which is incorporated with a primary object of promoting. If you don't use this word, gone. Marks are gone. Promoting science, education, social, culture, religion, sports, education, arts, commerce, etc. Second, profits, if any, surplus, if any, will be applied to the objects of the company only, but not to be taken by people. Dividends cannot be distributed, means a prohibition on distribution of dividend. What are the 3 things? Promoting the specific areas, 6-7 areas you have to write in exam. Second one will be, it should be the surplus, if any, comes in that particular process, it should be applied for the objects of the company only. And third one, prohibiting the payment of dividend. Now in this case, what they said, we wanted to continue for 10 years. Okay, continue for 10 years. I want to dissolve after 10 years. Dissolve after 10 years. Surplus, if any comes, you cannot eat it. You should be using it only for the objects. So what you have to do, you have to transfer that surplus to another Section 8 company having similar objects only, but you cannot distribute. So the argument of the group of individuals is not valid. That's the answer. So first you will write this now. It has objects of promoting commerce, arts, all these things. Profits or any other income should be applied only for promotion of objects. Dividend is prohibited. Okay, next, Section 890 on winding up or dissolution. Okay, if any thing is remains, means if any surplus is remaining after paying all the debts, they may be transferred to another company registered under this section with similar objects. Okay, then you have to do, or sir, there is no other company with similar objects in India, sir, I am the only one and only one. Then what to do? In that case, there is a fund created by central government called as insolvency bankruptcy fund. To that fund you have to transfer. Okay, in the instant case, the decision of group of individuals to form a limited liability company for a period of 10 years and to transfer the after dissolution, transferring surplus to them is not holding good. It's not right. Okay, the proposal is not feasible. Section 8 one question completed. Let us take Section 8 different question now. So one question we discussed about transfer of assets, whether possible or not. Okay, now we are going to see the overall alma mater of Section 8. Alpha School started imparting education on 1st April 2010 with the sole objective of providing education to children for weaker society, either free of cost at a nominal fees, depending on the financial condition. However, on 30th March, it came to the knowledge of central government that the said school was operating by violating the objects of objects clause, due to which it was granted the status under Section 8 of Companies Act 2013. Describe what powers can be exercised by the central government. Read the question, pause the video. Read the question. Okay. Let us understand the concept. Okay, see here. This particular school is there. They started for education purposes and nominal fee they are charging, but it came to the knowledge of central government that this school has violated the objects. What government can do? Simple answer. Listen carefully. 2 minutes we will discuss. First in exam, we have to write 3 points here. Section 8 company means a company which is incorporated to promote education, arts, culture, social, commerce, or sports, education, etc. Second, apply the profits only for the purpose of the objects, to promote the objects. Third, prohibit payment of dividends. 3 points you have written. Point 1. Tick. Second point. Section 8 company has to apply for a license to the central government. If the central government believe that this company will be definitely following all the primary condition, 3 conditions, and some additional conditions imposed. Those are specific company conditions. For example, I am a technology related company. Government will impose a technology related conditions. These 3 are common conditions for every Section 8 company. Additionally, relating to the company, they will impose conditions. If central government believe that they will follow all the conditions imposed, means main basic conditions and additional conditions on the basis of which license is granted, then it will give the license. But if 3 basic conditions are not fulfilled, or second one, if any condition, if 3 basic conditions are not fulfilled or any additional conditions are not complied with, or if they are doing any fraudulent activity or any activity violative, license which is given will be revoked. Okay, license is different, incorporation is different. Central government has given license will be taken back. Okay, once a license is taken back, you are a Section 8 company, Section 8 license is taken back, you are a Section 8 company, Section 8 gone, you will become a normal company, convert yourself into a public company or a private company, the option 1. If you are converted into private company, use the name private limited at the end. Public limited, limited you have to use, point 1. Or if conversion is not permitted, then it will be amalgamated with a similar company. So that is also not required. Then it will go for winding up. The answer C. I'm putting it before you. Pause the video, read the answer. Okay. Next, I have to do a question on Section 7. Section 7. Okay. Let us do one very big question such that all kinds of concepts will be included in that. Okay. Section 7, 2 questions I promised you. One is contravention of Section 7 we will do. Section 7 procedure also we will see. Okay. Question 1 and question 2 both are on Section 7A. One is a procedure in Section 7. Another one is contravention of Section 7. Okay. If you do these two now, no new question you need to do. Okay. Let us start. ABC Private Limited, a company that has been in operational for 2 years, was incorporated with submission of false information and suppression of material facts. Company founders Mr. X and Ms. Y provided incorrect financial statements and concealed significant liabilities during the incorporation process. Okay. This misrepresentation was recently uncovered during internal audit initiated by company's new CFO, Mr. Z. Upon discovering this fraudulent action, Mr. Z filed an application with NCLT. Explain the provisions of Companies Act 2013 in respect where a company has been incorporated by furnishing false or incorrect information. This is one type of question. Direct question, how it will come? Mahima Limited was incorporated by furnishing false information. As per Companies Act, state the powers of NCLT in this regard. Okay, read the question, pause the video, read the question. We will go into answer and solution. Just in 2-3 minutes, we will complete everything. Okay, read it. Okay, see here. So listen, if a company is in, I will directly come to the point. If a company is incorporated by furnishing false information or material misstatements, knowing it to be false. So if a company is incorporated by suppression of material facts or by submission of any false information, knowing it to be false, then the promoters of the company, then whom? The promoters of the company and the persons involved in the incorporation of company will be liable under 447. That is different. Okay. But NCLT, what it will do, he is asking, listen carefully. What about the company? Okay, there are 5 consequences. 5 consequences. Any one of them NCLT can take. Number 1, alter the memorandum and articles of the company. Alter the memorandum and articles of the company. Why memorandum articles alteration is required? Because directors of the company will derive powers from memorandum and articles. So first alter them. Alter memorandum and articles. And moreover, material misstatements were there in that memorandum article say. So therefore, alteration of memorandum articles. Number 1. Or number 2, as a punishment, convert the liability of the members to unlimited. Okay, next. If it is irreparable damage already occurred, go either for removal, shortcut, or go by full long method called as a winding up or any other procedure. But before taking any action, they will give a reasonable opportunity of being heard. That's it. Okay, next. Most important question, I think this will get repeated directly in the exam. One very, very big question came in examination. If you read this one single question, every single point in section number 7 will be covered. If any 1 or 2 points are not covered in section 7, I will show the charts material and I will discuss. Okay, first, Amrish, after completing his postgraduate degree in mechanical engineering from United Kingdom, returned back to India. Although he got a good placement in UK-based company, but he thought to build his own business empire in India. Amrish belongs to Barmer district in Rajasthan, where his parents have agricultural land of 20 acres. He planned to manufacture commercial drones for use of agricultural harvesting and assist in supplying chain process. For this purpose, he planned to incorporate a private limited company having the following persons as first subscribers and subscribers to the memorandum. How many? 6. Amrish himself, Robert, he is a college friend of Amrish. He is a citizen of UK. He has a technical expertise in order to incorporate the company, visited India on a valid business visa. Eliza, she is college friend of Amrish. She is a citizen of Netherlands and has good business contacts in European countries, which will immensely workful in marketing of the company products. Goma Devi, mother of Amrish, who is a illiterate. She has recently sold part of her agricultural land and received 15 crores, out of which she agreed to subscribe 5 crores, rupees 5 crores in share capital of proposed company. Good Work Technologies LLP, having expertise in the field of remote sensing devices. Mohit Electronics Private Limited company having expertise in the field of providing electronic and electricals. By the way, what kind of company he wanted to start? Okay, see here. He wanted to start a private limited company. 2 are required. 6 are there. Enough. So, Amrish planned to have a register office of the proposed company at Jaipur, while the factory and works shall be from Barmer. So, no problem. Register office is important. For incorporation of company, an application for registration is filed with the registrar. In the given case, initial subscribers of the company consists of one illiterate person, 2 foreign nationals, 1 LLP and 1 private limited company. Discuss the procedure. Read the question properly. Pause the video and read. I am not going to give any extra time. You know that. Read the answer. Listen carefully. This question, I have to show the answer and I will explain. One time if you listen, for the exams, it will be enough. Listen first. Point number 1. Whenever you wanted to incorporate a company, a document you have to take called as a SPICE 32. Okay, also called as a SPICE plus form. INC 32 is the number. In that form, electronically, you have to file for registration of a company. Here, the question is targeting not on procedure to incorporate. Okay, different persons are there. How they have to sign? On that memorandum and articles and on the SPICE document is a question here. Amrish himself, what he has to do? See, one by one, let us complete. Each subscriber and all the subscribers, in this case, Amrish, shall add his name, address, description, occupation. His name, his address, his description, and occupation. If any, in the presence of at least one witness who shall attest the signature, shall sign and add his name, address, description, occupation, if any. Simply, every subscriber to the memorandum has to give his name, address, description, and occupation in the witness of at least one more person. Next, Robert. This Robert is a foreign national residing outside India and he is visiting to India. And he wanted to sign. Yes, you can sign it by coming to India, but come with a valid business visa. In this case, anyway, he's coming with a business visa. Na? That's why he has clearly given in the question that, see, Robert, his college friend, he's a citizen of UK. He has a technical expertise in order to incorporate company. He came with a valid business visa. So valid. Eliza, is important. Netherlands citizen. Netherlands is not a Commonwealth company. Therefore, whenever the Commonwealth company persons are coming, country belonging to the Commonwealth, directly they can come with a valid business visa and sign and they can go. However, where the subscriber to memorandum is a foreign national residing outside India, his signatures and address on memorandum of association and proof of identity shall be notarized by a notary. Notary will check his status in Netherlands, whether it is valid or not, and then only he will sign. Since Eliza is a foreign national residing outside India, her signature and address on the memorandum or articles of association and proof of identity shall be notarized by notary. Repeated answer. Further provides that if a person residing in a country outside Commonwealth or which is not a party to the Hague Apostille Convention 1961, certificate of notary will be required, but it shall be authenticated by diplomatic or consular officer. So Eliza's documentation should be signed by a diplomatic or consular officer. Next, Goma Devi, illiterate, na thumb impression is required. Okay, thumb impression is required if she is a illiterate. Next, Good Work Technologies LLP. LLP is an artificial person who has to sign. Therefore, it shall be signed by partner of LLP, duly authorized by resolution approved by all the partners. Means what? All the partners in that LLP should first authorize one person. If our LLP has to become member in any other company, you should sign. That fellow will sign. Mohit Electronics Private Limited. Okay, where subscriber is a body corporate, the memorandum and article shall be signed by director, officer, or any employee duly authorized by the resolution of board of directors. Okay. With this, we completed question number 2. So seventh question, section number 7 completed, but section number 7 procedure they did not ask in the recent exam, that's why I did not put. So let us see what is the incorporation procedure one last time and close this discussion. Okay, whenever you wanted to incorporate the company, okay, see here, ordinary cases. First, Spice Place, simplified perform for incorporating the companies electronically. Application shall be filed with ROC. Which ROC? Within whose jurisdiction the registered office is to be situated, and with the following documents. First, EMOA, electronic. EAOA, duly signed by subscribers. Ordinary cases, subscriber shall add his name, address, description, and occupation, at least in the witness of one person. Illiterate na thumb impression is required. Body corporate na, it should be signed by officer authorized by the board. And if it is a LLP na, it should be authorized by all the it should be signed by such partner, authorized by all the partners. See, direct question came in exam from our chart. Say, foreign national residing outside India, his signature, address, and proof of identity notarized by notary public. If it is outside the Commonwealth, then it should be that notary public document should be authenticated by diplomatic or consular officer. And name, address, nationality, all of the details, just see a foundation of what you write. Just I am putting it before you. Pause the video and read the answer and complete it. Okay, ma? That's it. Okay. With this, we completed incorporation. You may get a doubt. Sir, doctrines are there. Now, doctrines I am going to cover at the end of our Companies Act revision. Okay. In the end, I will discuss about doctrines. Remaining all the concepts have been completed. So let us now start with the next unit, which is Prospectus and Allotment of Securities. In this particular chapter, the expected sections for the exam are section number 26, 27. 27 we already covered in section 13 because it's nothing but objects clause changed by a company which has issued shares to the public and amount is unutilized. Already covered. So I'm putting a wrong mark here because we covered already in incorporation. Next one, 28. 25. So I should write here 25. Next one, 30, 31, 34, 35, 39, 40, 42. These are all the sections. From this, 2 questions will come in exam from this chapter called as Prospectus. Okay, na? Guarantee question will come and 2 questions will come. One 3 marks question, one 3 marks question, or 3 and 4. 7 to 8 marks is the weightage of this chapter, Prospectus. These are all the expected questions. Okay. So from the question bank, wherever questions are referred in this part, we are going to cover that. Clear, everyone? Let's begin. Oh, good. First one is section 26. Board of Directors of Chandra Mechanical Toys Limited proposes to issue prospectus inviting offers from the public for subscription of equity shares of company. States reports which shall be the reports which shall be included in the prospectus for the purpose of providing financial information. Means there is a company. That company is a public company, wanted to go for public offer, wanted to issue prospectus. They are asking what details you should have. What details means which detail? Financial information they are asking. Okay. 26(1) says that every prospectus issued on behalf of a public company, okay, so should contain what? First one, number 1, it shall be dated and signed. So there should be a date on the prospectus and there should be sign. Okay. Now question. So sign, okay. Whose signature? There are so many people who will sign on the prospectus that we are going to discuss in another discussion. Okay. Another question is there, in that we will see. So first one, it shall be dated and signed. Number 2, it shall state such information which will give financial information about the company as SEBI will fix. So it should contain such financial information as the SEBI deems fit. Number 2. Next, third, SEBI did not give any, SEBI did not ask anything from my company, then what to do? If SEBI do not specifically ask your company as per SEBI guidelines, in general, what documents you have to submit, those you need to. So, prospectus shall make a declaration, until SEBI specifies information and reports on financial information, regulations made by SEBI shall apply. So, how to write the answer? Prospectus should contain the following information. It shall be dated, it shall be signed, it should contain such financial information as SEBI require. If SEBI do not require anything specifically until it specify, whatever the financial information is required as per SEBI regulations, those you need to state in the prospectus. Over. Next after that, prospectus shall make a declaration. Declaration means what? It's a promise or it's a confirmation, it's a certification. Declaration about compliance of provisions of Companies Act means in the prospectus clearly you should state that we have complied with all the relevant provisions of Companies Act, and a statement to the effect that nothing in the prospectus is contrary to the provisions of SCRA and SEBI. Super. Means what? Law compliance is the next part. Means you should give a declaration that prospectus is as per Companies Act, is not deviating SCRA, Securities Contracts Regulation Act, don't ask no, CA final, SEBI Act, CA final. Next. Accordingly, Board of Directors of Toys Limited, Chandra Mechanical Toys Limited, okay, which proposes to issue the prospectus shall provide reports on financial information as being specified by SEBI in consultation with the central government to comply with the above declaration. So, in simple language, 3-mark question here. What you need to write in exam? Point number 1. Every prospectus issued on behalf of a public company shall contain the following details. It shall be dated, it shall be signed, it shall contain such financial information as SEBI requires. Until SEBI requires something, submit that financial information as per SEBI regulations. Okay, number 5. Prospectus should contain a declaration that we have complied with the provisions of Companies Act. Prospectus should contain a declaration that, okay, prospectus should contain a declaration that we did not contravene the provisions of SCRA, we did not contravene the provisions of SEBI. That's it, answer is over. Okay, so question 1 completed. I will cover all section 26 related questions in exam, such that you will also have a clarity in continuity. Question number 2 in past exam questions. See. Comment on the following. Disclosure required to be made on the face of prospectus. Face of prospectus on a cover page. Next, conditions in regard to the expert statement. Very important. Date of publication of prospect. I will come from back to front. Okay. See here. Instead of going from top down, I will go from bottom to top. Okay. First, what is the significance, importance of date of publication of prospectus? Whenever you prepare a prospectus, prospectus has a cover page, correct? On that, you will write the date of issue. You will write the date of issue. And when this prospectus is printed, you will write whatever the date you mention there, that will be deemed as date of publication of prospectus. Means date stated on the face of the prospectus will be deemed to be the date of its publication. Sir, what is the significance, sir? Whatever date I write? No, listen carefully. Companies are going for public offer. Companies are going for public offer. When they are going for public offer, they should first give offer. Offer should be accepted. Then we will allot the shares. All these things will happen. Date of publication, why it is important? For example, on this, I have written 23/8/2026. Say for example. Now what will happen? This date will be treated as a date of publication of this prospectus. Date of publication of this prospectus. Your public issue of shares should be after this date, not before this date. If the issue happens before this date, immediately the public issue will become void because you are raising money without giving an offer. So therefore, date of publication is important. See, the date indicated in the prospectus shall be deemed to be the date of its publication. Okay, va? Okay. Now, next, conditions regarding the expert statement. Okay, na? See here. I will write down for understanding sake. See, conditions regarding the expert statement. Conditions regarding expert statement. Listen carefully. Whatever I will tell you, please listen carefully. Only one time I will tell. So listen properly. Listen now. Whenever you write expert statement answer, first you have to remember one point. Prospectus shall not contain the expert statement in following cases. Number one, expert is involved in FPM of company. Means this expert is not an independent expert. He is involved in the formation of this company, promotion of this company, management of this company. Such person cannot become expert. So such expert statement should not be included in the prospectus. So prospectus shall not contain the expert statement if in the following cases. Case number one, such expert is involved in formation, promotion, management, or promotion, formation, management of that company. Number one. Number two, not given written consent. Not given written consent means what? Expert has given his statement but did not give any written consent. Then expert statement is invalid. Whatsoever you give, whatever you want. Right? In simple language, you prepared a check. I wrote 1 crore rupee. Everything was written. Signature I did not put. Check valid. Check becomes invalid. Why? Signature important. Signature shows your consent. Like that, expert has given 10 pages documentation. Finally, he said, I will not sign. Consent is not given. Just because of the reason that he prepared 10 pages a document, that does not mean he is giving his consent. Consent means he should sign. So, if expert has given a document but did not sign on the document, such a kind of expert document should not be included in the prospectus. Number three. Given written consent and withdrawn before its registration. Means what? Prospectus should be registered with ROC or not? I gave document, I gave consent, but before its registration with the ROC, before it becoming public, I withdrawn my consent. In that case also, you cannot include expert statement because before its publication or before its registration, he has already withdrawn the consent. Clear everyone? That's it. So conditions are regarding expert statement. Prospectus shall not include a statement made by an expert in the following conditions. Okay, he is engaged in formation, promotion, management. I already told you. Number two, not given written consent. Already told you. Given written consent but withdrawn the consent before registration with ROC. That's it. Answer over. Expert consent document over. Next. Disclosure required to be made on the face of prospectus. Okay. First, on the face. Face means what? On the cover page of the prospectus, what disclosures you need to make? You need to make the following disclosures on the face. Okay, first one, you should clearly tell to the public that this prospectus is not a humbucker dummy. It is actually registered with ROC. It is the ROC registered copy. So you should tell copy has been delivered for filing to ROC. Okay, documents required by this section to be attached also should be there. Okay, previously we read one answer before that all documents are attached. With this, we completed section number 26. So I'm not going to waste our time also. Whatever the sections we have already targeted, let us round them. So what is completed? 26 is completed. Next, 27 already we completed there. Now our target is 30, 31. Red herring prospectus, shelf prospectus. Let us cover them. What is a shelf prospectus? State the important provisions relating to issue of shelf prospectus. Okay, listen first. Point number one. Shelf prospectus is issued by the companies which are having multiple public offers in the same year. Okay, so shelf prospectus is a prospectus which will be filed with ROC, and company issuing shelf prospectus need not issue any other prospectus for any public issue happening within a span of 1 year from the date of opening of first issue. Means 1 year is not one calendar year, 1 year is not one financial year. 1 year start from the date of first offer of securities. Okay, first offer of securities means what? There is a company, that company wanted to go for 4 public offers during the year. 1, 2, 3, 4. Okay, 1, 2, 3 and 4. First public offer starts on 1st June. Okay, next one on September, next one in November, next one in February. Okay, So like this, they wanted to make 4 different public offers. Yes, they can make 4 different public offers at a different time frames. For all these, one shelf prospectus is enough. So shelf prospectus is a prospectus which is not issued to public, which will be filed with ROC, and every time it goes for public offer, no further prospectus is required. Number 1. Okay, now question will come. Sir, for example, as you said, 1st June la I issued shelf with an indication that I will go for another 3 public offers in future. Anyway, prospectus contains the details of company. In 1 year, what details will change within the company? Every time prospectus cost, administrative cost will increase. Therefore, one prospectus I will issue for the next coming 1 full year. Idea is super. Okay, idea is what? Super. We appreciate that idea, but problem starts then. Okay, one problem enna, see here. 1/6 you go for prospectus issue. Between these two dates, and 1/6 ki 1/9 ki between, what happened na? There are some important changes that happened in a company which were not contained in this prospectus issued. Means you filed shelf prospectus na, in that shelf prospectus that information is not there. What information? Any kind of material changes happened in the company depending on the nature of company. New charges created, change in financial position. Like this, any important thing happened between these 2 dates na, that won't be contained in the shelf you already kept. Therefore, if there are any material changes or new charges created or any financial position changes, then you have to issue PAS2 information memorandum. Information memorandum will be filed with ROC. Filed with what? ROC. Now question will come. Sorry sir, I have one question. There is a subscriber. There is what? Subscriber. That subscriber has subscribed to the shares which will be issued after another 3 months. By paying application money, he paid. Okay. When 1/6K he paid application money in advance to the company and said that please take this money, allot me the shares. He gave money to the company because he already know that there are 3 public offers still pending. Correct? So with regard to the shelf prospectus, what are the points we need to write? First one, shelf prospectus is a prospectus which will be filed with ROC. Okay, filed with ROC, and once filed for further issue of shares for 1 year. Okay, no new prospectus is required. So number 2, other points inside the shelf prospectus. Number 1, shelf prospectus will be issued by companies which are allowed by SEBI. Okay. Second one, shelf prospectus will be filed with the ROC before opening of first offer of securities. In our example, 4 times they wanted na. First time when you are giving the offer, at that time you have to file with ROC. Okay. Validity period will be commencing from the date of opening of first offer. From the date the validity will begin. Validity will be for a period of how many years? 1 year from the date. Not one calendar year, one financial year, 1 year. Date to date we need to check. For example, if it is 23/8/2025, 22/8/2026 it will close. In that time, any number of public issues you can make. No new prospectus is required to be issued or filed. Okay. Next, whenever there are any kind of material changes or when any new charges created, changes in financial position which is not there in the shelf prospectus already filed with ROC, you have to file information memorandum in PAS2 at least 1 month prior to the second or subsequent issue. For example, as I said, company wanted to go for 1, 2, 3, 4. Okay, change happened between 2 and 3. Then what will happen? Third one is called as a subsequent offer, not second offer. 1, 2 between the second is a second offer, but third one is a third offer. Now third offer, fourth offer, like that they don't. Anything other than first 2 are called as subsequent offer. So if change happened between 1 and 2, then I will call information memorandum has to be filed before second offer. Okay, opening the second offer. But if the changes happen between 2 and 3, I will call it information memorandum should contain the changes made between subsequent offer of securities. between 2 3 between 3 4 etc. So for this separately prospectus is not required, but any material changes happen, any financial position changes, all these things you need to file with ROC through information memorandum in form PS2 at least 1 month prior to the subsequent issue or second issue. Okay, let's read. See here, shell prospectus means a prospectus where securities included therein are issued in one or more issues over a certain period. Okay, next. What is that certain period? Shell prospectus may be filed with ROC at the stage of first offer of securities as per the SEBI guidelines. 1 year is the validity period. 1 year commence from the date of first offer. Okay, no further prospectus is required for any second or subsequent offer. Next, information memorandum. Information memorandum will be filed, okay, prior to the issue of second one. Okay, at least 1 month prior you need to file. Where it is here in the rules, they given the time limit. So all material facts, financial position changes, okay, any new charges created and such other conditions. Form PS2 you need to file 1 month prior to the second or subsequent offer. Next, if I pay advance money, for example, there is a subscriber who subscribed for first issue and second issue both. For both he paid application money. First one if you pay, no, okay. Depending on the prospectus issued before the first offer, I also subscribed for the second offer. But in between there are some changes happened. Now what to do? You have two chances. Either shareholder can continue or you can withdraw the application money. If you withdraw the application money, refund all the money within next 15 days. That's it. Shall prospectus and information memorandum shall be deemed to be the prospectus. Answer completed. This is all about section number 31. Okay, yeah. Next, regarding the types of prospectus, let us cover first. Okay, next, past exam question, another question. The board of directors of ABC Limited are proposing to raise funds from the public through the issue of equity shares. However, due to volatile financial markets, the price per share and the number of shares to be issued are left open and to be decided post closure of the issue. As a financial advisor of the company, what would you suggest to the board in this regard as per the provisions of Companies Act? Let us understand one point. Whenever the company is not sure about, okay, at what price they have to issue the shares and how many shares they have to issue, there is one prospectus called as a red herring prospectus. What is a red herring? Red herring prospectus means a prospectus which do not contain complete particulars of price and quantum of securities to be issued. What will not be contained? Price and quantum of securities to be issued, it will not contain. So first point you have to write in exam. Red herring prospectus is a prospectus issued by the company to the public which do not contain complete particulars of price and quantum of securities to be issued to the public. That is one point. Okay, second point. Point number 2. What we need to concentrate on? Now we have to tell the characteristics of red herring prospectus. Red herring prospectus will be issued before opening of the issue. Before opening of issue, at least 3 days prior to the opening. Means if you are accepting application money today, 3 days before that only you have to issue red herring prospectus to public. Let the public read everything in the prospectus except price and quantum of securities and give their demand and price. All that I am not going to discuss today and waste your time. So on the point in exam, what you have to write, I am telling. First one, what is red herring? Red herring prospectus means a prospectus which is issued to the public which do not contain complete particulars of price and quantum of securities to be issued. Number 1, 1 mark. 4 marks, a question will come. Second one, red herring prospectus will be issued at least 3 days prior to the opening of first offer of securities. Number 2. Number 3, red herring prospectus will not contain complete particulars. So on the basis of the demands we receive, we will fix a final price. We will fix what here? Final price. The final price, that means red herring prospectus will be issued before issuing the final prospectus. Before issuing the final. 3 points I said now. Meaning of red herring prospectus, 3 days prior, it should be issued before issue of final prospectus. Number 4. That means final prospectus will contain the price, will contain the quantum. Red herring prospectus do not contain the price, do not contain the quantum. And final prospectus and red herring prospectus will have some variation. So the variations between red herring and final prospectus should be shown clearly in bold letters called as variation. Okay, wow. Next, red herring prospectus is a prospectus. Therefore, it contains all the liabilities of a prospectus. If you do any kirikiri with the red herring prospectus, liabilities under section 34, liabilities under section 35 will be applicable to you. See the answer. First, red herring prospectus does not contain complete particulars of quantum and price, 1 mark. Next one, red herring prospectus is issued prior to the issue of prospectus, 1 mark. Filing with the prospect at least 3 days prior, you should file, 1 mark. Next one, since it is a prospectus, it contains all the obligations of a normal prospectus, 1 mark. Next one, filing of red herring prospectus. When you are filing the final prospectus with ROC and issuing to public, final prospectus should not contain doubtfulness in price and quantum. It will contain the closing price and number of shares. So upon the closing prospectus stating, prospectus and red herring, final prospectus stating total capital raise, because now we know the price also. Okay, whether a debt or anything, and closing price will be available. 1 mark. Totally 5 marks question. Next. ABC Limited proposed to issue series of debentures frequently within a period of 1 year. Shelf prospectus again. We are not going to discuss. Already we have decided. What is a shelf? What is a shelf prospectus? All these things they ask. Again, same answer. Done. Next. This is a different question. 27. Yesterday already we completed a 13 objects clause change. First we are going to cover what? We are going to cover types of prospectus now. So we completed mainly 2. Number 1 will be red herring, number 2 will be shelf. Examiner, they are asking only these 2 most popularly. But in our hit list, what are there? 30 is there, 31 is, 30 is there, 31 is there, and we also have section number 28 to 25. But the 25, 28 questions are not coming in exam very frequently. But I will be covering for you, okay? Because I promise that I will cover for you those things also. Let us first see about one section called as Abridged Prospectus. Empty pillar it was given. Okay. What is Abridged Prospectus? Under what circumstances Abridged Prospectus need not accompany the information regarding prospectus along with application form? What are the penalties? Okay. Now, what is Abridged Prospectus? Whenever you issue any kind of application form, okay, you know application, allotment, first call, second call, final call. Application means what? Application money. Okay, that means what? See, there will be a document, and originally once upon a time there used to be a document called as application form. In a form, application form. Application form means what? I will be taking that application form, filling my name, address, details, bank account, everything I will fill, and I will also attach a account payee check, and I will send that back to the company through post. Company will collect the check in cash and tell your application money has been received. Again, we call it application money because it will be accompanied with application form. But problem is, application form is there, 2 pages, 4 sides, 1 fold will be there. I filled everything. Okay, check also attached, the jump clip given, sent to Mumbai, company register office, example. They took application money. Asala, on what basis you filled that application form? Or do you know what is that company? Or blindly you are filling it? Therefore, you should be making the applicant aware of your company. But every applicant, if you wanted to make aware, prospectus will be a 500-600 pages document. 500-600 pages document with one application form. If you send, how much printing cost for the company? Or sorry, now everything is electronic form. Even in that case, who will read that 500-600 pages now? Therefore, 500-600 pages prospectus there. You should condense that to 10 pages, not more than 10 pages. That is SEBI guideline. SEBI clearly said that abridged prospectus should not be more than 10 pages. Means what? A 500 pages content, you have to condense and minimize that to maximum extent. Most important information which will decide my investment or not to invest in the company in that abridged prospectus. That's abridged prospect. Okay. Now imagine, visualize. There is a 10 pages booklet. Booklet will have finally last page will be there. Na? Last page is a perforated page and holes will be there. You can tear that like a cinema ticket. Last page application form. Means what? Whenever you are asking application money cannot be asked independently. Application form should be attached to a prospectus. Full prospectus, it is abridged prospectus. Abridged prospectus is what? Abridged prospectus is a prospectus which contains the salient features of a prospectus. Salient means the most important features of a prospectus. Number 1. Okay, you cannot ask application money unless it is accompanied with an abridged prospectus. Number 2, you will get 2 marks. Number 3, in which cases abridged prospectus contents are not required? If you are accepting money from the existing members, for example, rights issue is there, bonus issue is there, already they know about your company, what you will tell again? Therefore abridged prospectus not required. Or underwriters will be there, underwriters will read about entire company and then only they will enter into underwriting agreement. Why abridged for them? They will read full prospectus, say. That's why when abridged prospectus need not be required, underwriting, public are not issued, existing members ka issued. Clear? Next. So abridged prospectus means a prospectus which contains salient features of a prospectus. Next one. Section 33 states that no application form for the purpose of for the purchase of any securities can be issued unless it is accompanied by abridged prospectus. But when not required, underwriting. Second one, no public issue. Third one, existing members. If you do not comply with that, 50,000 default ki penalty will be levied. Okay. That's it. Yeah. Abridged also completed. Red herring completed, shelf completed, abridged completed. Sir, you said 28 and 25, but not there, no, sir. What we will do now? That's why we will directly see the charts. We'll directly see what? Charts. See here. Section number 28. Exam lo question is not tested, but you should be careful. So let's see. This is section number 28. See the significance of section 28. I will first tell you. Okay. Section 28 is called as a proper offer for sale. Means what? See here. There is a company. This company is having equity share capital. Let us say 1 lakh equity shares of 10 rupees each. 10 lakhs is the capital. This 1 lakh is held by 3 different people. Okay. Group 1, Group 2, Group 3. Group 1 and Group 2 are promoters and founders. Group 3 is free float, also called as general public. Okay. In this 1 lakh shares, 25,000 shares promoters are holding. Okay. Let us say 26,000 shares are held by other founder members other than promoters who are involved in subscribers to memorandum, etc. And Group 3, free float is holding the balance 49,000 shares. And 49% public holding and 51% promoters and founder holding is there in this company. Now listen carefully. This company is a private public limited company which is unlisted. Means it never went for listing. Their shares are not listed in any stock exchange. Now listen to the story. This company la Group 2 is there na. These shareholders wanted to sell their shares in the open market. Okay, and get a market price for that share, and they wanted to leave the company. Now understand clearly, company is not raising any money. Already raised money from Group 2 shareholders. Now these Group 2 shareholders wanted to sell their stake to public. How many shares are there? 26,000 shares. Let us say, example I am saying. Okay, now Group 1 there are 3 shareholders. Group 2 there are 3 shareholders. Okay, or Group 1 3, Group 2 4. 7 members are required for a public company. 7 are there. Now they wanted to, okay, they wanted to sell the shares. These shares they wanted to sell. Sell to whom? General public. How many? 10,000 public they wanted to sell. Mean suddenly a 7 member, 10 member, 20 member company is becoming a 10,020 shareholders or not. So now listen carefully. Company is not raising any money. Company members are there. Those members wanted to dilute their stake. They wanted to sell their stake. They wanted to leave the company and go out. Okay. This concept is called as a offer for sale. Offer for sale means what? First thing, group of shareholders will first approach the board of directors and take the authorization of board of directors at a board meeting. Means what they will tell? We wanted to sell our stake to the public. Okay. You should do that for me. Means we are not going to sell directly because our shares are not listed now today. So we wanted to list them and sell them to public. Okay. So what we have to do? We will approach board of directors and ask them, board, please help me. Please what? Help me in selling my shares to the public. Okay. So board will ask, what should I do? You do one thing. Announcement should come from company directly. As if company is issuing the shares, you make an announcement. Say that you are going to sell the promoters shares. Sell what shares? Promoters shares. To whom? To the public. Okay, what I have to do? Company has to give an offer. Company has to give an offer. Offer for what? Offer for sale. That's how the word offer for sale came. Now, the offer for sale document will be there. Na? This offer for sale document will be deemed to be prospectus. That's what this section says. Okay, but listen carefully. Who is selling? Shareholders are selling. To whom? Public. But who is helping? Company. And who will issue prospectus? Who will issue offer for sale? Company. Who will do this entire process? Company. Who will spend all expenses? Company. Therefore, the expenses for this offer for sale will be taken back, reimbursed by the members. Fastly, let us read. First one. Authorize the company. So, where certain members propose in consultation with board of directors. Remember my example. To offer whole or part of their holding. In my example, part 26,000 shares. The members shall collectively authorize the company to take necessary action. So company has to take an action. They will reimburse the company all the expenses incurred. The document by which offer for sale is made to the public. Who will make? Company. Will make what? Offer for sale. To whom? Public. Will be deemed to be the prospectus. Because it is deemed, all liabilities for misstatement will apply. Next. What are all the sections in our target here? Section number 28 over. Okay, 30, 31 over. 30, 31 over. Now we have to cover 25. 25 also not given in exam. So therefore I will cover directly. I will cover what? Directly. Okay, see here. This is section number 25. Section number what? 25. See, I will first explain you fastly. Okay, listen carefully. See, there is a company. There is a issue house. There is public. Company, if it directly go to public and issue the shares, they don't subscribe because they don't know what is this company. There are totally in India, there are 11 lakh companies. Okay, hardly I will know, maybe 100, 200 companies I will know. What about the remaining 10 lakh company plus? So everyone don't know what every company is. So if company directly go to public, no one will subscribe. Therefore, what company will do? It will behave like SS Rajamouli. If you are not known in Bollywood, you should not go and show your face directly. Show your face through a known face in Bollywood. Same concept. Once you become popular, throw them away, you can directly approach them. This is concept of deemed prospectus under section number 25. What is this? Let me explain fastly. Okay. Company will issue, one time I will explain. What I said? So, one time if I tell, that is 100 times. If I won't repeat that. Okay. So only one time I will repeat. I will not repeat 100 times. One time if I tell, you should only repeat that 100. So please listen. First, 2 minutes is our target. Okay. Time starts now. Company will issue prospectus to the issue house. Prospectus is a document which is containing all the details. They will issue full prospectus to issue house. Issue house will read that prospectus, convinced with the prospects of that particular company, and issue house, believing that this company is a very good company, it will ask the company to allot the shares. So two things company has done: issued prospectus, allotted shares to issue house. Okay, issue house won't pay money today. It will take all the allotted shares and it will give an offer for sale to the public. Means instead directly going, issue house is a known person like Kotak Securities, SBI Cap Security, Access Capital, Edelweiss, or In Time, Link In Time. Like that, there are so many merchant banking companies are there. These people are very well known in the public. If these people say buy the shares, public will blindly buy. So this company will issue a prospectus and allot the shares to the issue house. Issue house will issue an offer for sale to the public. This public will now subscribe by believing in issue house. They will pay consideration. I call it whole consideration. Issue house has done so many things to company, na? They will deduct, okay, whole consideration minus commission, which is called as a net consideration. Means whole consideration is not received. And moreover, company allotted shares to issue house. Na? Issue house should allot those shares through sale to the public. This all procedure has to complete within 6 months from the date of allotment. If not, issue house will become the member. So this is the point. So full consideration will not be received, net consideration is received. Okay, now This is prospectus. This is deemed prospectus. In both cases, if you do any misstatements, any kirkiri in that, 34, 35 liabilities will get attracted. Last and final discussion. Listen, company is a company. This is the issue house. Company is issuing prospectus to issue house. Issue house is issuing offer for sale to public. Okay. Issue house can be company, LLP, partnership, anything it can be. Therefore, if it is a company, directors will be liable for misstatement. If it is LLP or partnership, majority of the partners will be liable. Okay. See here. Company has issue house and it wanted to issue to the public at large. Next. Meaning of deemed prospect. Where a company allots or agrees to allot any securities. Wait a minute. Where a company allots or agrees to allot any securities of a company with a view, I'm not allotting directly. My view is those securities shall be offered for sale to the public. Any document by which offer for sale to the public is made shall be for the purposes be deemed to be prospectus. Means my view is not to issue to issue house. My view is to issue to the public. Any prospectus which is issued to the issue house with a view to issue to the public will be deemed as a prospectus. Okay. Law relating to entire section 34, 35 will apply also to the deemed prospectus. Okay. Person making the offer or the person named as a director in the company. Next. Offer for sale should be completed within 6 months time. Whole consideration has not been received. Okay. Whole consideration has not been received. The important point. Next. Signature on the document. And the offer for sale document, who should sign? In case of company, 2 directors. In case of partners, at least 3/4 of the partners. At least 3/4 of the partners. So this is section number 25. In our important sections list, we completed 25, 26, 27, 28, 30, 31. Now our target is 34, 35, 39, 40 and 42. Okay, once these are completed, prospectus revision also will be sampurnam. We are going to complete prospectus revision as well. So 34 and 35. So let us see the 34, 35 and remaining sections. All statements contained in a prospectus issued by a company were literally true. Okay. It was also stated in the prospectus that company had paid dividends for a number of years, but there was no disclosure regarding the fact that dividends were paid out of realized capital profits and not out of trading profits. An allottee of shares want to avoid the contract on the ground that prospectus was false in material particulars. Read the question, pause the video. Okay. See, rather than reading like this, 34, 35, 36, directly we can read the charts because it's not a twisted question. It's a direct question they will ask. And like that, they will ask a question. You should write down what is a liability. Okay, wow? So therefore, I will directly show here. Please see the screen. First one. 34 is talking about criminal liability. Criminal liability. If a prospectus contains any statement which is untrue, you have to write this as it is in exam, or else they don't give you marks. Adi pakka. Okay, 1 mark will be given for this. If prospectus include any statement, so in the prospectus there is a statement which is included. How it is? Either untrue or it is misleading. Then person who authorizes the issue means what? Who will sign on that prospectus will be liable under section 447. Which section said this? Section number 34, criminal liability. Okay. Next one. Who will be escaping the criminal liability? If any person can prove that such statement or omission was immaterial. There is a statement which is untrue, or there is a omission, concealment of fact, but that is immaterial. That doesn't have any impact on, or that doesn't have any bearing on the investment made by a person. Such small clerical mistake, or it's a name related printing mistake. Those kind of immaterial things you should not consider. Next, that he had a reasonable ground to believe that statement was true or inclusion or omission was necessary. Means he bona fidely believed that that statement is true. That means he has no intention to do the fraud. By mistake it happened. So number one, it is immaterial, that a statement or omission is immaterial, or it happened by mistake, not with an intention to do that. Okay. Next, civil liability, the very important, listen carefully. Okay, first one, when civil liability section will get attracted, a person has a subscribed for securities, not purchased from stock market, subscribed for the securities of a company. Okay, sorry, how you subscribe? By reading the prospectus. So acting on any statement included or omitted in the prospectus which is misleading and sustained a loss or damage as a consequence. And here three sub points are there. Number one, you should be subscribing the shares. Subscribing means what? See, company issuing the shares. I'm directly taking from the company. That is subscription. Company issued shares to public, then went for listing. From stock market, if I purchase, that's not called as subscription. That's called as a purchase. That's called as what? A purchase. So when a person has subscribed for the securities of a company, subscriber. Next, how you subscribe? I acted on the prospectus. I believed in the statement made or omissions made. I thought that really that omission is required. And as a consequence, loss or damage is caused to me. Three things if satisfy, then you can claim civil liability. Civil liability. Okay. What civil liability? Company and every person who is liable? Director is liable. Which director? Sir, I'm a director on the date of prospectus issue, but not later. Okay, but case happened after 2 months or 3 months. I'm not a director by that time, but I was a director at the time of issue of prospectus. You are liable. So director at the time of issue of prospectus. Okay, next, who agreed to become director in future directors. Next, promoters. Next, who other person authorized, auditors, everyone. Next, expert under section 26(5). Okay, so like this, here also you can escape from civil liability. When you can escape from civil liability, expert can escape from civil liability, or any director can escape from civil liability if having consented to become director, withdraw the consent. Means what? I said that I will become director. I agree to become director in future. Okay, but I withdraw my consent. And I said that I don't want to become director in this company. But still prospectus my name was written. Then I'm not liable. Next one. Prospectus is issued without the knowledge or consent of that particular person. There is a director in Singapore, company is in India. He is not even knowing what is happening in India. Okay, they included his name also in prospectus. Okay, so without my consent, without my knowledge, you issued. Once you come to know about it, immediately give a public notice and a newspaper. You give an advertisement that I am not at all having any knowledge about this. Don't make me liable. So like this points will be given in section number 34 and 35. But most important thing that you need to understand is, previous question what they said, company said that we are issuing dividends every year, we are paying dividend, but it did not disclose that the payment is made not out of cash profits but out of capital profits. Because the dividends chapter, what we will read, dividend should be paid only out of what? Current year profits, accumulated profits, and third one, current year profits, accumulated profits, third one, both. And simply what you have to understand, accumulated profits, the free reserves. Which reserve? Free reserve. And really cash should be there. So you paid not out of the free reserves, you paid out of capital reserve, which is not a free reserve. Okay, that you did not disclose. Dividends are paid really, but paid not out of a proper source, paid out of improper source, that I did not tell. That concealment of fact make the prospectus misleading. Make the prospectus misleading. He will be liable in two things. Number one, 34 like criminal liability, 35 like civil liability. Okay, sir, what is the difference between criminal liability and civil liability? Criminal liability, you are liable under 447. Imprisonment, fine will be there. But in case of civil liability, imprisonment, fine illa. You made misstatement, you made wrong statement, you made false statement, you did not include a material fact, you concealed a fact. Believing in you, he purchased and he incurred loss. Compensation must be paid by you for the loss incurred. Okay, so therefore, every person or company shall be liable to pay compensation to every person who has sustained loss or damage. Along with that example, you have to write one point. Ade rescission of contract. Rescission of contract. Where a person has subscribed to the shares on the basis of prospectus containing a misleading statement. Okay. Effect. Contract to purchase shares become voidable at the option of purchaser. Okay. Exception. Right not available to subsequent purchaser from the market. Just now I told you, Sir, what is this, sir? I did not understand. Exam, whenever question comes from this prospectus, criminal liability, civil liability, write down the civil liability section first. Means if there is if a subscriber subscribe to the securities of a company from a company on the basis of the prospectus, depending on the inclusions and omissions made in the prospectus, and as a result incurred any loss or damage, he will be liable for he will be entitled to a compensation. Okay, who will be responsible of number 1, present directors, number 2, future director, number 3, promoters, number 4, every person who authorized issue, number 5, expert under section 26 subsection number 5. Okay, so they will be liable to pay compensation. Along with that, me being a shareholder can also cancel the contract and I can get back my money. That's called as a rescission of contract. Okay, who can seek? Any person who has subscribed to the shares. Subscription should be happening with the company. That will not be available for person who purchases from the stock market. That's it. With this, we completed section number 34 and 35. Eva? Directly, let me go to section number 39. Section number what? 39. See, 39 section is talking about allotment of securities. Allotment of what? Securities. So, allotment section says like this. See, a company cannot allot the shares to public unless two things are happening. Okay. First, minimum subscription must be received, which is 90% of the total subscription as per SEBI guideline. Okay. And moreover, that minimum subscription should be received in any form other than cash. Means what? In check or any other instrument only should receive. So, two conditions. Company cannot allot the shares unless two conditions are satisfied. Amount stated in the minimum amount should be received, and it should be received in the form of a check. Okay. Next. How much should be application money? It should be not less than 5% of the nominal value. If 10 rupees is the nominal value, minimum 50 paisa should be application money. Okay. Next. Minimum amount stated in the prospectus. Okay. If it is not subscribed within 30 days, as per SEBI, it is 60 days. Okay. If it is not subscribed within 30 days, you have to refund back the amount within next coming 15 days, or else you have to pay interest at the rate of 15% per annum. Refund shall be, and any refund is there, now that refund will be redeposited back in the same bank account from which you received main application money. Okay, that's it. This is what said in section number 39, allotment. Okay, next, whenever I say section 40, the most important thing is underwriting commission. Underwriting commission, how we have to pay? Underwriting commission will be paid first if it is authorized by AOA. If it is authorized by AOA. Next one, commission will be paid out of two sources. Number 1, proceeds of issue. Number 2, profits of the company, or both. Means from the money raised only you can pay underwriting commission, or from the profits of the company you can pay underwriting commission. How much commission I can pay? If it is the shares not less than, not more than the lower of 5% of the issue price or rate authorized by AOA. If rate authorized by AOA is 4, 5% or 4%, whichever is lower, 4%. Okay, rate authorized by AOA is 6, 5 and 6, whichever is lower, 5. Okay, debentures ki 2.5 or rate authorized by AOA. That's it. These are all some important contents in this particular segment. Okay, the only one thing that I am going to cover in another chapter, next coming chapter, share capital, I will cover. That concept is private placement. The concept is what? Private placement. With this, we completed all the important contents in the prospectus chapter. Next coming discussion is on share capital chapter. Another 1 hour discussion on share capital. We will brush through all the important contents. Share capital chapter, most important sections. Number 1, 43 section rule. Means it is talking about what is that? Differential voting rights. Number 1. Number 2, section number 48. Section number 55. Section number 56 to 59. This time one question compulsory will come from this segment. 1000% will come. My expectation. 56, 57, 58, 59. One question will be there in exam. Next. 61, 63. Next. 62, 67, 68, 70. Okay. These are all the expected sections for this exam. For this, we will cover first. Okay, once these are completed, then we'll go into next chapter. With the share capital completion, all the big areas in this syllabus will be over, except the general meetings chapter. Only the big area that will be left after all this is general meetings chapter. Okay, sir. Anyway, we will cover in a flow. This chapter will be our next chapter.